All right, members, let's start. House Judiciary Committee, please make sure that you sign in. And then once you got a minute to sign in, we'll have the clerk take the roll. Madam Clerk, can you open the board, please? Everybody, please sign in. All right, Madam Clerk, can you take the roll?
Madam Chair, you have 17 members present. You have a quorum.
All right, members, do we have any personal orders? Representative Eldridge, you're recognized.
Thank you, Madam Chair. I just want to recognize my district attorney sitting back here toward the back, Mr. Dan Armstrong. Make him feel welcome.
All right, anyone else? All right, let's get started. We're going to start with item number 1,
Motion.
House Bill 2139 by Speaker Marsh. Speaker Marsh, I have an amendment here, 014873.
That's correct. That's what I have.
All in favor of adding the amendment to House Bill 2139, please say aye. Sir, you're recognized. You can speak to your bill.
Thank you, Madam Chairman. This bill addresses cargo theft in Tennessee, which is a huge problem in both trucking and in rail thefts. It addresses a rapid growing form of cargo theft, creates a clear criminal definition for fraudulent freight theft, establishes a new statutory definement of fraudulent freight theft. This includes obtaining or diverting freight through deception, misrepresentation, impersonation, false pretenses, or identity fraud. This treats fraudulent freight theft as theft under the Tennessee law, recognizes freight theft schemes as ongoing criminal operations, and the main thing it does is allow for reports to be easily done in Tennessee when theft does occur. What's happening now is, say a rail car starts out in, just say New Orleans and goes to Chicago, and it comes through Tennessee. It starts out in Memphis, say, and it's going to Chicago. When they open the car, it's missing some of the freight, or it's missing all of it. There's nobody really now that files that report for the owner of the property to turn it into their insurance company. So this is establishing a path for better reporting so that you can get those reports timely and be able to turn them into your insurance carrier. That's basically all it does.
Representative Travis, you're recognized.
Thank you, Madam Speaker. Move previous question.
All right. Any objections to previous question? All right, members, we're going to be voting on House Bill 2139 as amended, moving to GovOps. Madam Clerk, will you open the board for voting? All those in favor vote aye. Those opposed vote no. Have all members voted? Does anyone wish to change their vote? Madam Clerk, please announce the vote.
Madam Chair, you have 17 ayes, 0 noes, and 0 present not voting.
Speaker, your bill moves forward to government operations as amended. Thank you. All right, members, let's move on to item number 3, House Bill 354 by Chairman Powers. Oh, you're going to do two? Okay. There's Chairman Powers. Thank you.
Yes.
All right. Chairman, I've got 014302 as an amendment.
Correct.
All right. All those in favor of adding 014302 to House Bill 354, please say aye. Those opposed say no. The ayes have it. You're recognized, sir, to speak to your bill. Thank you.
Thank you, Madam Chair. House Bill 354 gives TBI discretion to determine the best investigative approach of suspected elder financial exploitation. Instead of requiring coordination with the DA, as they are now required to do, this bill will allow TBI to investigate whenever appropriate. TBI may coordinate with the district attorney general, other law enforcement agencies, or it also allows coordination with prosecutors and other agencies when needed. In summary, House Bill 354 clarifies how TBI handles report of suspected elder financial exploitation. And with that, Madam Chair, I renew my motion.
Representative Towns, you're recognized.
Chairman Powell, thanks for the bill. Tell me this, how and who's going to report this? I mean, it happens all the time. It's happening everywhere. Who's looking out for them and their financial well-being and ensuring that information gets to the TBI quickly?
Chairman, you're recognized.
All right. Thank you, Madam Chair. Yes, we have, last year, we set up an elder financial abuse hotline through a TBI hotline. So that hotline goes directly to TBI. Then they coordinate. Right now, they're coordinating with the district attorney general to do anything. This will allow them to go directly if there's a urgent need for financial, because, once money leaves the country, it's pretty well gone. So if there's an urgent need to do that, then TBI can directly investigate it now.
Okay.
Representative Towns, you're recognized for a follow-up.
Thank you, Madam Chair. Look, so that means anybody can call the TBI hotline, right? I could call if I suspected something, correct?
Yes.
Okay, good.
Yeah,
Very good.
anybody, yeah.
Now, and I certainly don't want to make a false call. The other thing is this, is that you have cases where seniors' houses are being taken and switched out of their name. Does this address that at all? They find they don't have anywhere to live because sometimes members of the family, suckers stole the house over there.
Chairman Powers, you're recognized.
Yes, anybody can report it if it's done to, elderly person. And we do see that happening from time to time when the houses are switching another name and pretty well stolen, or they
That's right.
take out a loan, against that home and they've stolen the mortgage. But yeah, this will address all that. It's a $500 million business in Tennessee, and that's only the part that's reported. They figure about twice that much, or about $1 billion probably, but only about half of it's probably reported. A lot of times it's within the own family too.
Representative Hardaway, you're
Finally,
recognized.
Finally, one final try, Mr. Chairman. What's the age for the senior citizens? What age does it start? What we're looking at?
It's 65 and older.
Okay, thank you,
Yeah,
sir.
yeah.
Thank you, Madam Chair.
You're welcome. Representative Hardaway, you're recognized.
Thank you, Madam Chair. Simply put, is TBI okay with this?
Recognize. Okay.
Chairman.
Yes, TBI. Yeah, they helped us develop the original bill that we passed last year, and this is just making that small alternation. But yeah, they're fine with it.
All right, I want to thank you for bringing the bill to protect our elderly and other vulnerable populations. Thank you.
Representative Travis, you're recognized.
Thank you, Madam Speaker. Move previous question.
Any opposed to previous question? All right, members, we're going to be voting on House Bill 354 as amended with 014302. Moving on to calendar and rules. Madam Clerk, would you open the board for voting? All those in favor vote yes. Those opposed vote no. Has everyone had an opportunity to vote? Does anyone wish to change their vote? Madam Clerk, please count the vote.
Madam Chair, you have 18 ayes, 0 noes, and 0 present not voting.
House Bill 354 as amended moves to calendar and rules.
Thank you, Madam Chair.
All
Thank
right,
you, committee.
members, we're going to go back to number 2, House Bill 1317. We have an amendment 014109.
Correct. Rewrite
All right,
speech.
Chair Lady Littleton, thank you for that. All those in favor of adding amendment 014109 to House Bill 1317, please say aye.
Aye.
Those opposed say no. The ayes have it. Madam, you're recognized on your bill.
Thank you, Madam Chair. This bill, as amended, requires the sentencing court to determine when an offender shall begin the period of incarceration for driving under the influence.
All right, members, you've heard the explanation. Anyone have any questions? Representative Johnson, you're recognized.
Yeah, just to clarify quickly, the way I read this, it gives a judge actually more discretion. Is that correct?
Madam Chair.
That is correct.
Thank you.
All right, members, any objection to voting on House Bill 1317? All right, Madam Clerk, can you open the board for House Bill 1317 as amended? All those in favor vote aye. Those opposed vote no. Has everyone had an opportunity to vote? Does anyone wish to change their vote? Madam Clerk, can you count the vote, please?
Madam Chair, you have 18 ayes, 0 noes, and 0 present not voting.
House Bill 1317, as amended, moves on to calendar and rules. Now, let's move on to item number 4, House Bill 1816. Okay, we may have to, all right. Members, I apologize. Obviously, Chairman Williams is in finance right now. All right, let's move on to item number 5, House Bill 1444 by Chairman Gillespie. So Chairman, I don't see any amendments on this piece of legislation. Is that true?
Thank you, Madam Chair. For this, no, there are no amendments.
Wow, love it. All right, so you had a motion and a second. You're recognized on your bill.
Thank you so much, Madam Chairman and committee. House Bill 1444 strengthens Tennessee's response to the most extreme intentional acts of violence against animals by elevating aggravated animal cruelty from its current Class E to a Class D felony. This would also allow the courts to classify juveniles who commit aggravated animal cruelty as serious youthful offenders. These are not neglected cases, but we're talking about very deliberate violent acts. And with that, I welcome any questions.
All right, Representative Johnson, you're recognized.
Thank you, Madam Chair. Animal cruelty is a horrible crime, and people who commit that crime, especially young people, typically have some pretty deep-seated mental health issues. And my fear with this bill is that when you take tools away from a judge with this bill, that allows to get more mental health treatment. So for me, some of these juveniles need more treatment, not to be treated like an adult and put someplace where they will not get that mental health treatment. So that is my concern with this bill. I think we need to take it very seriously, animal cruelty, without a doubt. But I don't want to take tools away from a judge when it comes to a person who needs some pretty intensive mental health care.
Representative Gillespie.
Thank you so much. I'll just say that this bill aligns penalties with, in my opinion, the gravity of the offenses. It will also equip the courts to intervene when juveniles show this level of dangerous behavior. For juveniles, early structured intervention works better than waiting until later. And a lot of these times we're waiting until later, and that just isn't working.
Any follow-up?
Yes. Well, this isn't about waiting till later. This is immediately getting that mental health care. And that's the thing that is so critical, because I spend a lot of time working with kids like this and know exactly what it means when kids commit those acts. But being treated as an adult is not the best way to go here. It's really to double down on the mental health care. But thank you.
Very good. Representative Stinnett, you recognize.
Call for the question.
Very good. Members, this question has been called. Any objection? All right, seeing none. Madam Clerk, if you'd open the board, members will be voting to send House Bill 1444 to Finance, Ways and Means. All those in favor vote aye. Opposed vote no. Has everyone been voted? Let's change the vote. All right, Madam Clerk, you take the vote.
Mr. Chair, you have 15 ayes, 5 noes, and 1 present not voting.
Very good. Members, House Bill 1444 is moving to the Finance, Ways and Means. And that brings us to item 6, Representative Gillespie as well. Members, that's House Bill 1484.
1484.
So you got a motion and a second on the bill. I'm looking at 2 amendments, 14525 and 16905. Would you like to go with the latter?
The 16905.
Very good. Members, you've heard it. You got a motion and a second. Any objection to adopting House Amendment 16905 to House Bill 1484? All right, seeing none, all those in favor say aye. Aye, opposed say no. Ayes have it. Now we're back on the bills amended. You're properly recognized.
Thank you so much, Mr. Chairman and committee. This is the Memphis Safe Task Force Accountability Act. What we're trying to do here is to bring a greater level of transparency for the public for certain offenses, and I can tell you what they are if you ask. But certain offenses for the prosecutors to disclose when a plea is either lowered or dismissed. And this would require, with the amendment, it would be a monthly reporting as opposed to it was a daily reporting. And it would sunset in 2 years.
Forgive me, you heard the explanation. Any questions? Representative Johnson, I have you first on the list.
Thank you. This says Memphis Safe Task Force, but as I read this bill, it includes everybody across the state through the bill language. So I'm curious, where are the DAs on this bill? And is it possible that we can hear from them?
Thank you. Representative Gillespie, any follow-up?
Thank you so much, Mr. Chairman. So this is very specific to violent federal task force that are being set up now or in the future. So, but my goal is the immediate situation at hand, which would be the Memphis Safe Task Force. Secondly, I've worked very heavily with the DA's conference, with the U.S. Marshal's office, with the United States District Attorney's office, and many others on this, and they've all had their buy-in, and everyone's okay with it.
Good. Any follow-up?
Yes, there are violent task force all across the state. And so that's why I'm wondering if the DAs in every area are on board with this. And if we could hear from them, if they're here.
So we could if they had signed up and they didn't. So any additional questions? All right, very good. Representative Travis, you recognize.
Thank you, Mr. Speaker. Question on the bill.
Very good. Any objection? All right, very good. We're seeing objection. Members were on the board. All those in favor of the previous question, vote aye. Opposed, vote no. Very good. Madam Clerk, take the vote.
Mr. Chair, you have 13 ayes, 6 noes, and 0 present not voting.
Very good. Previous question prevails. Members will be voting to send House Bill 1484 as amended to count and rules. All those in favor vote aye. Opposed, vote no. Madam Clerk, you open the board. Several members voted. Any member wish to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 13 ayes, 6 noes, and 0 present not voting.
Very good. House Bill 1484 as amended is moving to calendar and rules. That brings us to item 7. That's House Bill 2563 by Representative Gillespie. You got a motion and a second. I'm looking at House Amendment 14857.
That is correct.
Very
That
good.
makes the
Motion and a
bill.
second. Members, we'll go ahead and adopt that amendment. Any objection? Seeing none, all in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you so much, Mr. Chairman and committee. This bill as amended would create 20 additional assistant public defenders positions, 20 legal secretary positions, 12 investigator positions, and 7 social workers positions. This was brought to me by the Public Defenders Conference. Thank you so much.
Very good, members. You've heard the explanation. Any questions? All right, seeing none, any objection to the question? All right, seeing none, Madam Clerk, if you'd open the board. Members, all those in favor of sending House Bill 2563 as amended to Finance, Ways and Means, vote aye. Those opposed, vote no. Has everyone voted? Any member change the vote? All right, Madam Clerk, if you take the vote.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 2563 as amended is moving to Finance, Ways and Means.
Thank you.
Thank you. And that brings us to the next bill, item 8. That's House Bill 2023. Chairman Martin, you got a motion and a second looking at House Amendment 16454, sir.
That is correct, Chairman.
You got a motion and a second. Members, any objection to adopting the House Amendment 16454 to House Bill 2023? Seeing none, all in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Chairman and Committee. This bill here is working with victim assessment fees, and what we're looking to do is go from 45 up to 125 if the county so chooses. And this is helping with our victim assistance programs, and these funds would have to be directly and exclusively used for that. And with that, I stand ready for question.
Good. This is permissive.
Yes, sir.
Very good. Members, any questions? Seeing none, any objection to the question? All right, seeing none. Members, Madam Clerk, you can open the board. Members, we'll be voting to send House Bill 2023 as amended to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member wish to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 17 ayes, 0 noes, and 1 present not voting.
Very good. House Bill 2023 as amended is moving to Finance, Ways and Means.
Thank you, Committee and Chair.
All right, members, next on the items on the agenda is item 9, House Bill 1755 by Chair Lady Rudder. And ma'am, you've got a motion and a second, and you are properly recognized at your leisure.
Good morning.
Morning.
House Bill 1755 adds a mandatory minimum sentence of 30 days incarceration for persons convicted of driving under the influence if the person was within a marked school zone and warning flashers were in operation. I stand ready for questions.
Very good, members. Do we have any questions for Chair Lady Rudder? Seeing none, any objection to the question? Seeing none, members, looks like we're going to be voting to send House Bill 1755 to Finance, Ways and Means. Madam Clerk, if you'd open the board. Members, all those in favor, vote aye. Opposed, vote no. Is that member voted? Any member wish to change their vote? Very good. Madam Clerk, if you take the vote.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 1755 is moving to Finance, Ways and Means. And that brings us to item 10, House Bill 1757. You got a first and a second. And members, we have House Amendment 16064. Got a motion and a second. Members, any objection to adopting House Amendment 16064 to House Bill 1757? All right, seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Members, I want to give you a little background on this piece of legislation before I actually present the House Bill 1755. While celebrating the 4th of July with his wife and family, Mr. John Cobb was struck and killed by a stray celebratory bullet during a fireworks celebration. John was an active member of his community, serving as worship leader in his church for 20 years. John's wife, Miss Michelle Cobb, administered CPR, not knowing that her husband had been struck in the head by the bullet. John was transported to Vanderbilt by helicopter and eventually declared brain dead. His lungs, kidneys, and liver were donated to help save the lives of 3 people. The Winchester Police Department and TBI are still investigating this incident. John and his wife own guns. She is not seeking broad gun control. The family simply wants people to be informed of the dangers and allowed to prevent it from happening to others. So House Bill 1757 will make it a Class A misdemeanor if a person recklessly discharges a firearm into the ground, air, body of water, or an object in proximity to the person if the firearm is discharged at a place of public gathering or a public event where there are at least 25 people in attendance at the time of the discharge. Also, this information must be included in all department-approved handgun safety courses. And I ask for your support of this legislation as we honor Mr. John Cobb, and I stand ready for questions.
And thank you for that explanation. Members, any questions for Chair Lady Rudder? Representative Johnson, you're recognized.
Thank you, Mr. Chairman. I appreciate this bill. That is such a tragedy. My concern is if it's a law enforcement officer, this bill doesn't count. And I know we just saw New Year's where an ICE officer fired into the air and killed a man in the community. And I'm wondering why you didn't include those folks when they're, outside of their duty. It seems like it would be important to include everyone.
Chair Lady Rudder.
I really just didn't think about a law enforcement officer firing a gun into the air in a celebratory fashion.
Right, might be good, sounds like a good piece of legislation for next
Yeah,
year.
that
Members,
would be
any
a good
additional
piece of
questions?
legislation for next year.
Representative Johnson, you're recognized.
Yeah, I just, it sounds good for right now. Yeah, I agree. But I understand, but I wish that carve out wasn't in the bill because I do like the bill. I'll still vote for it, but maybe I'll think about that
Maybe
for
you
next
carry
year.
that legislation next year.
I will. And I'll
All right,
ask for your vote on it.
Any additional questions for the sponsor? All right, seeing none, any objection to the question? All right, seeing none, Madam Clerk, if you'd open the board. Members, we're voting to send House Bill 1757 as amended to calendar and rules. All those in favor vote aye, opposed vote no. Is there a member voting? Any member wish to change the vote? All right, Madam Clerk, if you take the vote.
Mr. Chair, you have 20 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 1757 as amended is moving to calendar and rules. And that brings us to item 11, also with Chair Lady Rudder. We have House Bill 2442, members. You've got a motion and a second. Looking at House Amendment 14433. Got a motion and a second. Members, any objection to adopting House Amendment 14433 to House Bill 2442? All right, seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized.
Thank you, Mr. Chairman. This is a District Attorney General staffing bill. This bill provides for 248 positions within the District Attorney General's conference and provides placement throughout the judicial districts.
Very good, members. You've heard the explanation. Any questions? Representative Johnson, you're recognized.
Thank you. So one thing that's not included here again is the attorneys that do the indigent, take the cases for indigent. They probably make some of the least money in the state. And I definitely support this legislation. But again, I would also like to see that appointed counsel also get an increase as well.
I think there's a different bill that would take care of that.
Thank you.
Very good. Members, any additional questions for the sponsor? All right, seeing none, any objection to the question? Seeing none, Madam Clerk, if you'd open the board, members will be voting to send House Bill 2442 as amended to Finance, Ways and Means. All those in favor vote aye, opposed vote no. Has everyone voted? Any member wish to change their vote? All right, Madam Clerk, if you take the vote.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 2442 as amended is moving to Finance, Ways and Means. And that brings us also to item 12. That is House Bill 2443 by Chair Lady Rudder, and you're probably recognized.
Thank you, Mr. Chairman. This is a DA bill and has support of DHS. House Bill 2443 clarifies that a parent's obligation for support of a child does not continue after the child reaches 19 years of age unless the child is handicapped or disabled, regardless of where the child is in the education system.
Very good, and thank you for that explanation. Members, any questions for Chair Lady Rudder? Seeing none, any objection to the question? Seeing none, Madam Clerk, if you'd open the board, members will be voting to send House Bill 2443 to calendar and rules. All those in favor vote aye, opposed vote no. Has every member voted? Any member wish to change their vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 2443 is moving to calendar and rules. And that brings us to item 13, also by Chair Lady Rudder. That's House Bill 2465. You have a motion and a second and no amendments, so you're probably recognized.
Thank you, Mr. Chairman. This bill closes a significant sentencing loophole in the law by ensuring that attempt, conspiracy, and solicitation of enumerated violent offenses are treated consistently with the completed offenses. This adds to the list of certain offenses required to be served at 100% of the sentence imposed. Currently, offenders do not serve 100% of the sentence for these crimes. Tennessee also already requires 100% service for most serious violent crimes. However, attempt, conspiracy, and solicitation of these violent crimes are excluded, even when facts show extreme violence or near completion. Prosecutors routinely encounter cases where the only reason a crime was not completed is because the victim fought back and escaped or survived, or the defendant took substantial steps toward completing the violent offense and demonstrated full criminal intent. The intent of this bill is consistency, and public safety under the truth and sentencing model for Tennessee. I ask for your support.
Very good, members. You've heard the explanation from the sponsor. Any questions? Any objection to the question? Representative Johnson, you want to be recognized?
Yeah, it'll be quick.
Okay.
Just one concern. I'm teetering on this bill, but one of my concerns is in the fiscal note where it talks about they kind of look 3 years out, but we're talking about this could be 20 years out or 30 years out. So when you consider what that is, are they really considering, what the cost of this is going to be? And I think that that's something we should be thinking about as we think about this bill. But thank you.
Thank you.
Very good. Any additional questions for the sponsor? Any objection to the question? Madam Clerk, if you'd open the board, members will be voting to send House Bill 2465 to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Has everyone voted? Any members change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 15 ayes, 2 noes, and 0 present not voting.
Very good. House Bill 2465 is moved to Finance, Ways and Means. That brings us to item 14. That is also by Chair Lady Rudder. House Bill 2466, you got a motion and a second. I'm looking at House Amendment 14274. Members. Very good. Members, any objection to adopting House Amendment 14274 to House Bill 2466? All right, seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Mr. Chairman. This bill updates reporting requirements for the DAs and provides 3 ways for clerks to give information to the district attorney generals. Thank you.
Very good. Thank you for the explanation. Members, any questions for the sponsor? Representative Johnson, you're recognized.
I'm so sorry. But so one thing that I heard about this was it's incredibly burdensome for the clerks. Are they okay with this or?
I haven't checked with the clerks, but
Okay,
I hope they are.
thank you.
All right, members, any additional questions for the sponsor? All right, seeing none. Any objection to the question? All right, seeing none. Madam Clerk, if you'd open the board, members will be voting to send House Bill 2466 as amended to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Has everyone voted? Any member wish to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 16 ayes, 0 noes, 1 present not voting.
Very good. House Bill 2466 as amended is moving to Finance, Ways and Means. And that's all I have for you, unless you have another one. down the
No, I'm
calendar.
good.
Are
I
you
think
good?
I've been here
Okay,
long
I was like-
enough. Thank
All right,
you.
thank you. All right. And House Bill 2221, item 15 by Representative Sherrill, sir. And you got a motion and a second. Members, I'm looking at House Amendment 14509.
Yes,
You got a
sir.
motion and a second. Members, any objection to adopting House Amendment 14509 to House Bill 2221? All right. All those in favor vote aye. Aye. Opposed, no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Chairman. House Bill 2221, 4 years ago, we passed a bill creating a criminal proceeding negotiation system under the Sheriff's Association. The system lets a victims register anonymous once the offender is booked and allowed them to receive notifications as their case progresses through the court system. This November, the voters will likely adopt Murphy's Law into the Tennessee Constitution. The criminal proceedings notification system is necessary to comply with the Murphy's Law, as our Constitution will soon mandate that victims have the right to notifications throughout the court process. The notification system only works if the data is there for the criminal court clerks. The bill simply mandates that the clerks will make the applicant data available to the TSA for the administration of the criminal proceedings notification system. So we have 68 counties that are currently participating in the program, and this bill will help to get the remaining counties on the system.
Very good, members. You've heard the explanation. Any questions? All right. Representative Hardaway, you recognize, sir.
Thank you, Chairman. To the sponsor, does this affect Memphis, Shelby County?
Representative Sherrill.
Should affect all counties if everything goes through.
We got any additional questions?
I'm still not clear. You said initially that 68 counties were already engaged. Was Shelby one of those? To my knowledge, no. And there hopefully will be on the system when this all goes through.
Right.
All right. Thank you, Chairman.
Very good. Members, any additional questions for the sponsor? Seeing none. Any objection to the question? Seeing none, Madam Clerk, if you'd open the board. Members, we are going to be voting to send House Bill 2221 as amended to counter rules. All those in favor vote aye. Opposed, vote no. Has that member voted? Any member wish to change the vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 20 ayes, 0 noes, 0 present not voting.
Very good. House Bill 2221 as amended is moving to calendar and rules.
Thank you, Chairman and members.
All right, members, we're going to go out of order. We're going to move to item 25, House Bill 2301 by Representative Freeman. So you got a motion in a second. Members, I'm looking at House Amendment 16643. Got a motion and a second. Members, do we want to go ahead and adopt House Amendment 15634 to House Bill 2564? Any objections? Seeing none, all those in favor vote aye. Aye. Opposed, vote no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized.
Thank you, Chairman and Committee.
And I may have. Okay, all right, item 25, House Bill 2301.
Yes, sir.
Okay, very good. Okay,
Yeah.
we're in good shape.
And the amendment is on now,
It's 16643, correct?
16643. Yes,
Okay,
that's
correct. You're probably recognized.
Thank you, Chairman and Committee. And I'm just going to briefly describe what this bill does and talk a little bit about what my initial intent was. So working with the subcommittee, we ended up with a version that we see before us. And what this does is simply increase the penalties for someone drink spiking. The initial bill had an additional requirement in the second section that would have required testing strips. And in talking through that in the subcommittee, we realized that's probably a little difficult to do. So that's not part of this bill. And I've talked to many of you about that before. So again, all this bill does is increase the penalties for people spiking drinks. 1 in 5 rape cases are under the presence of some sort of drug. And this is going to hopefully curtail some of that. With that, I stand ready for questions.
All right, members, and just for clarification, I believe I accidentally had mentioned the number for the amendment on the next bill, which was 15634. The amendment that we voted on would have been Amendment 16643, which is the proper amendment for this bill. We're in procedurally, we're fine. I just want to make that clear.
Okay, thank you.
So members, any questions for Representative Freeman? Representative Alexander, you're recognized.
Not a question, just a comment. I want to thank you very much. I had a dear friend's daughter have her drink spiked when not on Broadway, and it could have really been really bad, but luckily they got her to the hospital quick enough. So thank you for doing
Sure.
that.
Yeah, Representative Freeman, you're
Chairman,
recognized.
to that, the number of people that have come up to me privately since I've been working on this bill who've shared similar stories, I think we're going to find it's more prevalent than we
realize.
currently think it is. And this is just going to hopefully be able to charge folks that are doing this for the crime they're committing.
Very good. Representative Towns, sir, you're recognized.
Mr. Chairman, thank you. And years ago, I passed a bill, Chairman Freeman, that actually removed the statute of limitation on rape. If it's reported within 3 years, they find out about it, 20 years later, they still can prosecute them. And that's good. And with this bill, absolutely, I think, give us that extra oomph that we need to have, and I'd love to sign on to the bill when we get a chance. But it is a problem. It's been a problem. And this allows us, especially after working with your restaurateurs, to address it, hopefully in an effective manner. Thank you.
Very good. Representative Travis, you're recognized.
Thank you, Mr. Chairman. Previous question.
All right, members, previous question has been called. Any objection to the question? All right, seeing none, Madam Clerk, you'd open the board. Members, we're going to be voting to send House Bill 2301 as amended to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Is that member voted? Any member wants to change the vote? All right, very good. Members, House Bill 2301 as amended is moving to Finance, Ways and Means. And sir, if you'll stay right there, you also have the next bill on the calendar. Oh, excuse me. Let's do this. Let's take the vote first. All right, Madam Clerk, if you would take that vote on.
Mr. Chair, you have 21 ayes, 0 noes, 0 present not voting.
Very good. Now, members, House Bill 2301 as amended is moving to Finance, Ways and Means.
Thank you, Chairman and Committee.
There we are. All right, item 26, House Bill 2564. So you got a motion and a second. Members, I'm looking at House Amendment 15634.
That's correct.
All right, very good. Do I have a motion and a second? Motion. Second. You got a motion and a second there. Members, any objection to adopting House Amendment 15634 to House Bill 2564? All right, seeing none. Any objection? All right. All those in favor of adopting House Amendment 15634 to House Bill 2564, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Chairman and Committee. This bill is amended, expands access to victim services. It would create a 2-year pilot program in Nashville and Memphis. They require the clerk to notify victims of the services that are available in those counties. And with that, I stand ready for any questions.
Very good. Members, any question for the sponsor? All right, seeing none. Any objection to the question? All right, seeing none. Madam Clerk, you'd open the board. Members will be voting to send House Bill 2564 as amended to calendar and rules. All those in favor vote aye. Opposed, vote no. Has there been voted? Any member wish to change your vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 18 ayes, 1 no, 1 present not voting.
Very good. Members, House Bill 2564 as amended is moving to calendar and rules.
Thank you, Chairman and Committee.
Very good. All right, members, we'll back up the calendar to item 16. That is House Bill 2428 by Representative Capley. So we got a motion and a second, and you're probably recognized.
Thank you, Mr. Chairman. Thank you, committee. Many of you will remember we did the Back the Blue Act a couple years ago. Many of you supported it, signed on. I appreciate that. This will essentially increase the assault against first responders as well and add that to the Back the Blue Act. That's what the bill does.
Very good, members. You heard the explanation. Any questions for the sponsor? All right, seeing none, any objection to the question? Okay, seeing none, Madam Clerk, if you'd open the board. Members, we're going to be voting to send House Bill 2428 to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member wish to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 16 ayes, 0 noes, 2 present not voting.
Very good. House Bill 2428 is moving to Finance, Ways and Means, sir. You'll stay right there. You also have item 56 on the calendar. Members, we've moved without objection to item 56. That is House Bill 1802. Very good. You got a motion in a second. You're probably recognized.
Thank you, Mr. Chairman. Thank you, committee. House Bill 1802 establishes that a person who's not engaged in conduct that would constitute as a felony and who's in their place for their lawful residence is justified under certain circumstances in using deadly force if immediately necessary to prevent or imminent commission of certain property offenses. This is one of the only 2A pieces of legislation that made it out of the great Senate sweep that happened not too long ago. So I would ask for passage. It made us in Judiciary.
All right, members, without objection, we're going to roll this 5 spaces.
Okay.
All right. Okay. All right, members, that brings us back to item 17. That is House Bill 2147 by Representative Jones. Representative Jones, I'm looking at 2 amendments. I've got 13671. I've got 16581.
16581.
Very good, members. You've heard it. Any objection to adopting House Amendment 16581 to House Bill 2147? Without objection, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
So the amendment does not rewrite the bill. It is an amendment that ensures the continued operations of FAA regulated commercial flights by maintaining consistency with federal aviation standards.
Very good. Members, you've heard the explanation. Any questions for the sponsor? Seeing none, any objection to the question? Seeing none, Madam Clerk, you'd open the board. Members are going to be voting to send House Bill 2147 as amended to calendar and rules. All those in favor say aye or vote aye. Opposed, vote no. Has every member voted? Any member wish to change the vote? All right, Madam Clerk, you would take the vote, please.
Mr. Chair, you have 16 ayes, 0 noes, 2 present not voting.
Very good. House Bill 2147 as amended is moving to calendar and rules.
Thank you.
That brings us to item 18, House Bill 849. And ma'am, you have a motion in a second. I'm looking at House Amendment 15676.
156. That's correct.
Members, I got a motion in a second. Members, any objection to adopting House Amendment 15676 to House Bill 849? Seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Mr. Chairman and committee. The intent of this bill is simple. It's just to ensure that AI does not qualify as a person under Tennessee law. They should not be able to sue for patents, copyrights, run for office, or claim rights, all of which are actually already happening someplace in the world. Tennessee Code does use the term person in many, many places, and that word determines who can hold rights, who can enter contracts, bring lawsuits, or be held accountable under the law. This bill just clarifies what is not included in that definition, and it makes clear under Title I that the term person does not include artificial intelligence, computer algorithms, software programs, computer hardware, or any other type of machine. Recently in Cheyenne, Wyoming, a candidate named Vic, virtual integrated citizen, appeared on the ballot for mayor. Vic was not a man. It was a custom-built AI. Across the world, a multi-billion-dollar international corporation called NetDragon appointed an AI named Tang Yu as the CEO of a subsidiary company. So this bill is just simply saying that machines really can assist people, but they do not qualify as people under the law.
And thank you for that explanation. Members, any questions for the sponsor? Any objections to the question? All right, seeing none. Madam Clerk, you'd open the board. Members, we're going to be voting to send House Bill 849 as amended to calendar and rules. All those in favor, vote aye. Opposed, vote no. Has everyone voted? Anyone wish to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 17 ayes, 0 noes, 2 present not voting.
Very good. House Bill 849 as amended is moving to calendar and rules.
Thank you.
And that brings us to item 19. That is House Bill 1692, members. You got a motion and a second, and the latest amendment I'm seeing is 16412.
That's correct.
Okay, members, you've heard it. You got a motion and a second. Any objection to adopting House Amendment 16412 to House Bill 1692? All right, seeing none. All in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized.
Thank you, Mr. Chairman. Under current Tennessee law, judges already have the discretion to waive a homestay requirement when a child is related to the petitioners. So this amendment extends that same discretion, but under more defined and rigorous conditions to a non-related petitioner. Under the amendment, a court may waive the homestay requirement when all 3 of the following conditions are met. First, the child has lived with the prospective adoptive parent for at least 12 consecutive months. Second, the adoptive parent or parents have obtained custody order through a final court order following a full adjudication on the merits. And third, the waiver petition must include current background checks, including a TBI criminal background check and a Tennessee sex offender registry check. In addition, the bill does require that the court enter a written order with specific findings that waiving the homestead is in the best interest of the child. And then this bill does make clear that the courts are not required to waive the homestead. The decision remains fully with judge's discretion. With that, I stand ready for questions.
Thank you for the explanation. Members, you've heard the explanation. Any questions for the sponsor? Representative Johnson, you're recognized.
Thank you. I guess my concern right now, we are seeing so many problems in DCS. And what we're seeing is people with overburdened caseloads. They're not being able to check in on their caseloads as often as they should. So, you know, in a perfect world where I feel like DCS is up to par on doing their job, I think that this might be okay. But it's very concerning to me in the current situation where they can't get to all the kids on their caseload. They're not getting to all their kids on their caseload. I'm just not sure they're getting all the safety checks they need. So if things were operating as they should, I would definitely support, and I appreciate what you're trying to do. But under the current system, with the backlogs that they have and everything else, I think that we should do everything that we can to make sure we're putting those kids into a good situation. When I was teaching, I had a student who was in the process of being adopted. He had been in foster care with this family for a long time. What happened in the family, though, the father had diabetes, and he started having problems. He had to have his toes cut off, and then his foot, and then he lost his leg. And just that turmoil in that family in the last bit really changed the dynamic. And that kid ended up, they placed him, but then they did not, they ended up giving him up. And that was such a tragic thing to see happen. So I just think that before we make this big step, that we should do our due diligence every time. So thank you.
Representative Renaud, any follow-up?
Yes, thank you. This does not apply to cases where DCS is involved. This is going to be specifically for private adoptions where the child has already been in the petitioner's home for some period of time. Oftentimes, how this bill came to me was that there is an attorney who deals with a lot of these cases in rural districts where a birth mom might leave a child with a neighbor and because they can't take care of the child. And after some period of time, the judge has already given some sort of judicial either placement or custody order to that prospective adoptive parent. So we're just trying to remove duplication of process where there's already been established a safe home. There's already been a judicial order placing and allowing that child to stay in that home, because these families oftentimes don't get to the point of where they're ready to file for adoption until the child's ready to go to school, where they realize they need to have that custodial permanency. And so the point of this is to reduce the cost of attorney fees, the home study fees, and to do the duplication of process when the home has already been established as safe by a judge through a prior order.
Very good, members. You heard.
And
Any additional questions? Representative Johnson, you recognize.
Yeah, I just want to follow up, and I do appreciate that, but I just, even if DCS is not involved, so there's not anyone checking, I really think that we should just make extra certain that this is going to be the place, because adoption is hopefully final.
Very good. Representative Stinnett, you recognize. Very good. Previous question has been called. Any objection to the question? Seeing none. Members, Madam Clerk, if you'd open the board. Members, we're going to be voting to send House Bill 1692 as amended to calendar and rules. All those in favor vote aye. Opposed vote no. Is there a member voted? Any member wish to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 17 ayes, 3 noes, 0 present not voting.
Very good. House Bill 1692 as amended, moving to calendar and rules.
Thank you, Committee.
And as I understand it, item 20, House Bill 985 will be taken off notice without objection. And that brings us to item 21. I have House Bill 1346. I saw Representative Reeves down there. Sir, you've got a motion in a second. I'm looking at House Amendment 15358, sir. And you
That's
have a
correct,
motion in a
sir,
second.
yes.
That's correct. Members, any objection to adopting House Amendment 15358 to House Bill 1346? All right, seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. And we're back on the bill as amended, and you're recognized.
Thank you, Mr. Chair. So this was brought to me by a local judge about a year and a half ago, and we waited to run this bill because this section of code dealing with expunctions was being rewritten last year. I think it's a lot more streamlined than it was, but it is a narrow, what I think is a responsible step that supports recovery court participants without weakening the expunction laws. And today, under this code, a single DUI, no matter how old that is, can permanently block someone from expunging a later totally unrelated minor offense. And this bill says that if at least 10 years has passed and that person has successfully completed a certified recovery court program, they may seek an expunction for a different later offense that's already eligible under the current law. And that's what the bill does.
Members, you heard the explanation. Any questions for the sponsor? Any objection to the question? All right, seeing none, Madam Clerk, if you'd open the board. Members, we're going to be voting to send House Bill 1346 as amended to Finance, Ways and Means. All those in favor vote aye. Opposed vote no. Has everyone voted? Anyone wish to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 19 ayes, 0 noes, 0 present not voting.
Very good. House Bill 1346 as amended is moving to Finance, Ways and Means.
Thank you, Chair and Committee.
That brings us to item 22, House Bill 1235. Representative Love. Sort of looking at two amendments. The latest amendment is 15456.
Yes, sir.
Very good. Members, any objection to adopting House Amendment 15456 to House Bill 1235? Seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Mr. Chairman, committee members. As I expressed in the subcommittee, research has determined that several of our children who are in foster care whose parents had some benefits that they could have inherited are not getting all the benefits. And we've been working with DCS on this amendment, which will just allow them to find ways to set aside some of the money for our young people that doesn't jeopardize any future benefits they may receive. And that is the crux of this bill and amendment, Mr. Chairman and members.
Members, you've heard the explanation. Any questions for the sponsor? Representative Travis, you recognize.
Thank you, Mr. Chairman. And Representative Love, does this go into a trust for these kids? Is that how this works?
Representative Love, you recognize.
Thank you, Mr. Chairman. Yes, sir. That would be determined by DCS. One idea we did use was to see if they could use for a 529 plan for them for the future, but also for some children who would not desire to go to college. We're leaving up to DCS to determine what may be the best way to do this. I think the amount that we determined at one point was it was about $7 million that was could have been utilized directly for the children.
Any follow-up, Representative Travis?
Question on the bill.
The question has been called. Any objection to the question? Seeing none, Madam Clerk, you open the board. Members, we voted to send House Bill 1235 as amended to GovOps. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member wish to change a vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 19 ayes, 0 noes, 0 present not voting.
Very good, members. House Bill 1235 as amended is moving to GovOps.
Thank you, Mr. Chairman and committee members.
All right, that brings us to item 23, House Bill 2432 by Representative McKenzie. So you got a motion and a second. I'm looking at House Amendment 15065. You got a motion and a second. Members, any objection to adopting House Amendment 15065 to House Bill 2432? All right, seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended.
Thank you, Mr. Chair. This bill extends the statute of limitations for prosecution for vehicular homicide within 10 years of the date of the offense. This allows for more time if needed. This bill was brought to myself, Senator Briggs, by Michelle Lawson. She's a Knoxville native. Lost her son Quentin after a UT football game. Stepped into the curb across the street and was tragically and instantly killed. During the grieving process, it took her a while to get her composure. And so about 18 months afterwards, she got some information that this person might have been impaired, but was told by the police department at that point, the statute of limitation was 1 year and had expired. So they can no longer investigate. So what this bill does, and it puts us in a line with 47 other states in the union that have similar laws. So with that, I stand for questions.
Very good, members. Any questions for the sponsor? Any objection to the question? Madam Clerk, if you'd open the board. Members, we're going to be voting to send House Bill 2432 as amended to calendar and rules. All those in favor vote aye. Opposed, vote no. Has every member voted? Any members change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 17 ayes, 1 no, and 0 present not voting.
Very good. House Bill 2432 as amended is moving to calendar and rules.
Thank you, Mr. Chair and committee.
That brings us to item 24, House Bill 2481 by Representative Parkinson. All right, you've got a motion and a second. I'm looking at
Thank you, sir.
No amendments, so you're probably recognized.
Thank you, Mr. Chair. This is a cleanup bill, allows the DA's conference to purchase software for state employed DAs and for locally employed DAs.
Very good, members. You've heard the explanation. Any questions for the sponsor? Seeing none, any objection to the question? All right, Madam Clerk, if you'd open the board. Members, we'll be voting to send House Bill 2481 to calendar and rules. All those in favor vote aye. Opposed, vote no. Has everyone voted? Any members change their vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 19 ayes, 0 noes, 0 present not voting.
Very good. House Bill 2481 is moving to calendar and rules.
Thank you, Mr. Chair. Thank you, Chairman, for the motion and the second.
And we've taken care of items 25, 26. Item 27 will be rolled 1 week without objection. And that brings us to members without objection. We're going to move to item 58 by Chairman Bolso. Very good, sir. You got a motion in a second, and I'm looking at several amendments. The latest amendment is 16241.
Yes, Mr. Chairman, that's the correct amendment.
Very good. Members, you've heard it. Any objection to adopting House Amendment 16241 to House Bill 1491? All right, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized.
Thank you, Mr. Chairman. Members, this is a bill that seeks to put voluntary vocal prayer back into our public schools. As many of you know, from the beginning of the country until 1962, we had voluntary vocal prayer in public schools. There was a Supreme Court decision called Engel versus Vitale that took prayer out of public schools, but our recent Supreme Court precedent has revised the way the court looks at the Establishment Clause, and this bill is consistent with our recent Supreme Court precedent. The bill also requires K through 12 curriculum to include teaching of the Bible as history and literature. Parents may opt children out, but that beginning with the next renewal of our curriculum standards, the Bible will be taught K through 12. Thank you, Mr. Chairman. I'm ready for questions.
Very good, members. We do have two individuals that signed up to speak on behalf of this legislation. Any objection going out of session here from those folks? All right, seeing none. And we have Ms. Flaharty and Ms. Cohen. If you ladies would like to come up here, and I believe you've both been here and had experience with those microphones. So just once again, the red light will come on and you'll have 2 minutes apiece, and then we'll open it up for questions. So Ms. Cohen, we'll just start with you. And once
Okay.
again, if y'all just introduce yourselves and then we'll go from there.
My name is Johanna Cohen. I'm from Robertson County. I have a few questions about this bill. Representative, as a purported Catholic, if the Bible is to be taught, then which Bible would be used? For literature, the King James is considered to be the best. For historical purposes, many would recommend the Westminster Oxford Study Bible. For critical understanding, the New Standard Revised. Tennessee has its own state Bible, the Atkin Bible. And according to many lists, the New International Version is the best-selling Bible. Thomas Jefferson also had his own version of the Bible, aka the Life and Morals of Jesus of Nazareth, where he kept the words and teachings of Jesus and removed the miracles and more mystical parts, including references to the resurrection from the Bible. Second, previously, Representative Balso made a point that the Establishment Clause binds Congress but does not bind the states. However, I would like to point out that the Tennessee Constitution also has built into it the freedom of religion. In section 3, it says that all men have a natural and indefeasible right to worship Almighty God according to the dictates of their own conscience, and no man can of right be compelled to attend, erect, or support any place of worship, which is in line with the First Amendment of the U.S. Constitution that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And I realize that some would point out that it says Almighty God and not any other word for God, but I would also point out it says all men, and we understand women have a right to choose their religion as well. Finally, the fiscal note, which sets aside $471,000 over 2 years for purchase, but also stands to lose $500 million from the Every Student Succeeds Act, $255 million from Individuals with Disabilities Act, $28 million from the Carl Perkins Act, $400 million from various USDA school meal programs, on top of whatever amount may be needed for potential lawsuits. This bill should not move forward. As a tax-paying Tennessean, I don't think using $471,000 and possibly losing a substantial amount of funding is worth passing an unnecessary and unconstitutional bill.
Thank you. Your 2 minutes is up and I really appreciate that. And ma'am, if you go ahead and introduce yourself, you'll have the same amount of time.
My name is Macy Fluharty. I'm a Davidson County resident living on Cherokee, Yuchi, and Shawnee land. The bill before us marks a public education system, a system for people of all religions that is being harassed by Christian nationalists and bigoted legislation. Science, math, and reading scores are declining in this country and hardly making a turnaround in our state. It's hard to keep children engaged. Reasons for this have often been found to be things like bullying, exclusion, stress, trauma. Establishing a religion within our school system can exacerbate these concerns and exclusionary acts within the student body, even up to extreme bullying. If a student experiences religious trauma, having to come into a school that perpetuates that trauma is harmful. Public school is for all children of all backgrounds. Passing a bill like this turns that place into a safe space for just some and unsafe space for others. I'd also like to mention the extra workload this puts onto teachers, including the emotional tax it takes for someone who does not believe in a religion to have to speak against their own faith. Our teachers are underpaid and underappreciated as is. This is demeaning to them. We've got places for people to study and worship the Bible, private schools, churches, youth groups, local organizations. Encroaching onto public schools with the clear Christian nationalist agenda is shameful. The sponsors of this bill have made it clear that they like to revert back to the 1950s and seemingly even further back to the 1700s when some states had established religions. How do we think this will pan out in 2026? It will not. This Christian nationalist agenda being pushed by the far-right extremists cannot survive in this day and age, and especially not in a country that claims to be the land of the free. This bill needs to be voted down. Thank you.
And thank you for that explanation or that testimony, for better words. Members, any questions for our guests? All right, seeing none. Thank you all. Any objection going back into session? All right, seeing none. Any questions for the sponsor? Representative Jones, you recognize. Johnson, excuse me.
Confuse me. Thank you, Mr. Chair. I guess once again, what I'm going to have to talk about is you're asking our teachers to teach something that's not in the standards, and they already struggle every single day to be able to get in everything they need so that the kids can be proficient for the test that they have to take with all the materials that they have to get in. And so my question, I guess, is when this is not one of the standards, when they are already overburdened, and we have added so much in this legislative session to what they have to teach, how are they supposed to add anything else or allow kids time out other than the designated time we already have every morning for a prayer and the pledge? So can you tell me what this is going to look like in a school and how teachers are going to get through everything they have to do in the day when we keep adding to their burden?
Chairman Bolson, you're recognized.
Thank you, Mr. Chairman. Yes, as you'll note from the bill, the portion that you're speaking about is the portion that deals with teaching the Bible K through 12. And the bill specifies that that portion of the bill is not to become effective until the Board of Education once again reviews the applicable academic standards for ELA and for social studies. So this K through 12 curriculum will be rolled into existing ELA and social studies standards the next time the board reviews those academic standards.
Any follow-up?
Yes. So what are they going to remove so that they can have time in their day to do this? Are we going to remove some of their reading instruction, some of their math instruction, some of their science instruction, because there's already not enough time in the day for educators?
Chairman Bolson, any follow-up, sir?
Yes, Mr. Chairman. My response would be that I think our Board of Education does a very good job modifying our standards from time to time. As you know, Shakespeare cited the Bible more than 1,300 times in his works. So I'm very confident that our Board of Education will be able to weave the teaching on the Bible as history and literature in with our other academic standards.
Very good. Any follow-up, Representative Johnson?
Yeah, I guess as long as we're weaving in all the other religions as well, so as to not be in violation.
Very good. Next on the list, I have Representative Ashley. You recognize, sir.
Move previous question.
All right, previous question has been called. Any objection to the question? Seeing none, Madam Clerk, you'd open the board. We're going to be voting to send House Bill 1491 as amended to education. All those in favor vote aye. Opposed, vote no. Is there a member voted? Any member wish to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 14 ayes, 4 noes, 0 present not voting.
Very good. House Bill 1491 as amended is moving to education. Members, we could back up just one spot to item 57. That's House Bill 2317. Representative Barrett. Sir, you've got a motion and a second. Looking at House Amendment 16390. Members? You got a motion and a second there as well. Members, any objection to adopting House Amendment 16390 to House Bill 2317? All right, seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Mr. Chairman. Thank you, members of the committee. This bill as amended does create the new criminal offense of grooming with various stages of offense and how that is defined in the bill. I'll stand ready for questions, and hopefully everybody's had an opportunity to read through this.
Good members, we do have some folks here. I have, if you don't mind, without objection, got a session here from, I have in support, I have Miss Connie Reguli. She's here, and then that's really all I have, ma'am. If you want to come up here and speak, you're more than welcome to. You're on the list. And ma'am, I believe you're up here before, so once the red light's on, you'll have 2 minutes just introduce yourself, and just we'll listen to what you have to say, and we'll go from there.
Good morning. My name is Connie Reguli. I'm a former family law attorney who now operates a platform called the Family Forward Project. representing and speaking for 29,000 families. I'm speaking in support of the bill, and I want to thank the brave mother from Illinois who brought this and suggested this after her child was groomed by a 34-year-old teacher. I want to share with you why Tennessee needs this bill. A few years ago, I represented a mother in Warren County. Her daughter had some behavioral issues and ended up under the jurisdiction of the juvenile court. The judge ordered the 17-year-old to remain under probation until she was 19 and ordered DCS to provide youth villages intercept counseling services. The child remained at home and was assigned a one-on-one counselor who could communicate with the child personally and come to her home even when the parent was gone to provide counseling. The counselor began using this relationship to communicate privately with the child and enticed her into a relationship. As soon as she turned 18, it turned into full-blown sexting. The child had a total meltdown and ended up in the streets of Nashville. I obtained those text messages, but there was nothing we could do. The child was afraid and shattered. As I sat here today, I hold in my hand 13 news reports over the last 2 years of teachers and coaches in this state who have been arrested for sexually inappropriate behavior. Putnam, Bradley, Dixon, Williamson, Davidson, Bedford, Rutherford, Hamilton, Sevier, Sumner, and Knox County are all named here. I'm currently working on a case in Montgomery County where a teacher showed a nude image of himself to a female student in class, and law enforcement said that there was not enough evidence to arrest him under the current sexual exploitation of a minor because the teacher said it was an accident. Children deserve the highest level of protection from predators that we can design, and I urge you to vote yes.
And thank you for that. Members, do we have any questions for our guests? All right, seeing none. Thank you for being here. Any objection, go back into session. Seeing none, back into session. Any questions for the sponsor, members? We have Representative Johnson, you recognize.
Thank you, Mr. Chairman. And I do appreciate this bill. I've actually worked with someone that I think would have fallen into this category. However, I'm a little concerned about the language and how are we going to determine what is actual grooming. I feel like it should be a little more specific. So what are your thoughts there? How do we determine this?
Representative Barrett, you're recognized, sir.
Well, thank you, Representative Johnson. Thank you for the question. In the first section of the bill, we define the course of grooming conduct and what that is. That lays out what the provisions are that are going to have to be proven in order to determine whether grooming conduct has happened. Also, if you look below that, in item number 4, there's the definition of what a predicate act is. And so that definition, there's 5 different predicate acts that go into. If any of these predicate acts, one or more of them are present, that's going to step up the basis for the offense. So then if you flip over into paragraph B and C, that breaks down what the offense is. So there's the offense of committing the offense of grooming a minor. As far as, hold on, let me make sure I'm telling you right on that. Yes, so the offense of grooming a minor is described in subparagraph B that breaks that down, talking about whether or not you have committed any of those predicate acts in connection with that activity. And then also C, the offense of grooming a minor while in a position of trust. So we have 2 different offenses now. And in those offenses, based on different factors that go into that, will determine which offense or which penalty will be subject to application in that case. So the offenses are going to start with a base of a Class A misdemeanor and can go all the way up to a Class B felony, depending upon the age of the victim as well as the age of the perpetrator. And we had to back up and redefine that using this age differential, working with the TBI and the DA's conference to make sure that we weren't violating what was already on the books. So that's how we arrived at this 10-year differentiation to come up with these 2 different defenses. So we started out with 1 crime and we bifurcated it into 2. So now we have 2 different pathways for law enforcement to protect our children from these offenses.
Okay, thank you. I do appreciate the work. I just worry, especially we're in a climate where people are calling librarians or teachers groomers. It's very frustrating because it is a definite thing and it has a definite appearance. And just because you don't support banning books does not make you a groomer. So I think that we need to be very specific with the language. So thank you.
Very good. Members, any additional questions for the sponsor? Oh, excuse me. I'm sorry. Representative Barrett, you're recognized, sir.
Thank you, Mr. Chair. Just quickly to address that, in paragraph D2, there are exceptions so that we specifically eliminate some of those concerns. Teaching curriculum on human sexuality, sexual health, sexually transmitted diseases, that does not fall under this, specifically excluded. Also have diagnosis, examination, or treatment of a minor by a licensed healthcare provider, that's excluded. Communicating with a minor in the course of a lawful investigation is excluded. Age-appropriate conversations about puberty, human sexuality, birds and the bees, that's excluded as well. Any physical contact that is customary and appropriate as far as coaching, athletics, things like that, and any conduct of a law enforcement officer. So we've made careful steps to make sure that we are not opening Pandora's box for everybody and anyone to be accused of this.
Very good. Thank you for the explanation. Members, any additional questions? Any objection to the question? Madam Clerk, if you'd open the board. Members will be voting to send House Bill 2317 as amended to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Is there a member voted? Any member wish to change the vote? Madam Clerk, if you take the vote.
Mr. Chair, you have 16 ayes, 0 noes, 0 present not voting.
Very good. Members, House Bill 2317 as amended is moving to Finance, Ways and Means.
Thank you, Mr. Chairman. If I could have a personal order real quick,
You're
even though I'm
recognized,
not a
sir.
member of the committee. Just want to recognize I have a job shadow today from Lewis County High School, Andy Starcher. Go ahead and stand up, Andy. Andy is the state secretary for the Future Business Leaders of America and is running for a national office at the national convention this summer. So she's going to be running the state one of these days. Thought y'all might want to go ahead and meet her today.
Well, appreciate you being here. Thank you. All right, members, without objection, we're going to move to item 50. That's House Bill 2606. Representative Salinas.
Second.
Ma'am, you got a motion and a second. Looking at House Amendment 15513.
That's correct.
Very good. Members, any objection to adopting House Amendment 15513 to House Bill 2606? All right, got a motion and a second. I don't see any objection. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized. And we do have folks here to speak, so you just let me know when you want to do that.
Thank you, Chairman. This bill is very simple. It would create a department of cold cases under TBI. Currently, we only have one person that deals with cold cases. This would create 5 positions and a director level position. We've worked with TBI on this, and this bill was brought to me by Senator Roberts, as well as many of the families that are here to testify today. And while the bill is simple, it provides justice and hope for our families that have endured a great loss. So with that, I would like to go out of session to hear from the families.
Very good. Members, any objection going out of session? Seeing none. And I have on the list, I have Casey Robinson and I have Johnny Carter. Representative Salinas, is that correct?
Yes.
Very good. If y'all would just want to step up here to the either side, have a seat. And once you get up here, just once your red light on the microphone comes on, you'll have 2 minutes. Just be sure to introduce yourself, and then you'll have 2 minutes to say whatever you would like to say, and then we'll move on. So I'll start with whoever will start first.
Okay.
Go.
Hi, Chairman, Committee. My name is Casey Robinson. Today I am here as a little sister and an aunt. My older sister, Jennifer Wicks, and my niece, Adriana Wicks, who was just 2, disappeared 22 years ago in Springfield, Tennessee, Robertson County, 2004. I'm also here representing families across the state with their permission and support of this bill. Elizabeth Diane Bond from Sumner County, Jody Brooke Anderson from Davidson County, Janie Sue Lindsay from Carroll County, Nico Lisi from Williamson County, Freddie Lewis Whittier Moore from Haywood County, Marqualis Davis in Montgomery County, Bethany Markowski from Madison County, and Jonathan Ellis in Washington County, Layla Santinello, Sullivan County. They are missing, and they are your constituents. The problem is structural. Agents are working both new cases and older cases. So when new cases come in, our cases get put down and set aside for another day. So over time, families are forced to become investigators. We make the calls. We chase the leads. Many cases sit at the local level for years where agencies simply don't have the manpower or funding to investigate older cases. In February this year alone, 33 new missing persons cases were added in Tennessee. We are now ranked number 6 in our nation. It is not under control. It is a problem. Think about this. If 33 people disappeared today from downtown Nashville, it would be a crisis. There would be funding and there would be dedicated task force teams. But because it's happening one at a time, one by one, it's not met with the same response. This committee oversees justice, so I'm asking you directly today, how is it justice whenever families are doing the work themselves? How is it justice when today's active cases become tomorrow's cold cases? Here's what our bill does. It allows the TBI to create a cold case unit with dedicated agents focused only on cold cases. Other states like Texas, Florida, California, and Georgia already have them. Tennessee is behind. We are not naive. We understand there are other issues in this state that need funding. But if everyone in this room knew what it felt to have someone they love completely disappear, you would want it at the top of the list. Letting cases sit is already costing families their only chance at justice. I'm asking you to support this bill because right now the message to families like mine is if you want answers, go find them yourself.
Thank you, ma'am. Your 2 minutes is up. You're recognized. If you please introduce yourself, your red light's on, you have 2 minutes.
Hi, my name is Johnny Carter, and I'm the mother of Bethany Markowski. Bethany disappeared when she was 11 years old on March the 4th, 2001. It's 25 years ago, from somewhere near Jackson, Tennessee. Bethany was sassy, sweet, with just a little bit of sprinkle of attitude. She had a heart that was so big she didn't know what to do with it. Early on, after Bethany disappeared, I took a polygraph, and I passed. But there was one moment during that polygraph that broke me. When they asked me, have you lied to or deceived anybody in your family in the last 6 months? Sorry. I said no, and I stopped. And then I started crying because I remembered the week before Bethany disappeared. She was nervous and she didn't want to go. This was her second visitation with her father. And she was asking everybody in the family, what are you going to do if he doesn't bring me home? Dad's not going to bring me home this time. But I was following the law. I got her enrolled in school when she needed to be enrolled in school. I was making sure that I was following everything that I needed to do to protect Bethany. The night before she left, we were in the walk-in closet. She was sitting on the floor and she was crying and she said, Mom, I don't want to go. What if Daddy doesn't bring me back this time? And I just looked at her and I said, baby, he has to. It's the law. And if he doesn't, I'll come and get you. But if I don't let you go, I'll be breaking the law and I could go to jail. And unintentionally misled Bethany that night to make her feel safe. And I didn't keep my promise. Bethany didn't come home. And that's weight and guilt that I have to carry or have carried for the last 25 years. For 25 years, I've made the calls. I've tracked leads. I've built relationships with investigators. I've filed FOIA requests, and I've driven to meetings like this. Because if I don't, who will? When I stop speaking Bethany's name, she'll disappear all over again. I'm not a detective. I'm a mother. But this system has made me become both. Imagine sitting in a room with 7 TBI agents and FBI agents to be asked for me to be patient with them when it's been 25 years. What you heard from Casey is true. The new cases come in and our files get put down. And every year that passes, witnesses age, as do us parents. And in our case, some witnesses pass away. Memories fade and evidence disappears. In Bethany's case, we know that firsthand. But here's what I need you to understand. Bethany's case is not cold because there are no answers. It is cold because there has not been a dedicated team whose job has only been to find them. With today's technology, DNA advancements, digital forensic tools that didn't exist in 2001, cases like Bethany's can still be solved. The evidence still exists and the answers are out there. We just need somebody to help us go look for them.
Thank you, ma'am. That's all the time you have. I've let you go an extra minute there just to kind of get that point across, and we really appreciate that. Members, do we have any questions for our guests? Any questions? Any objection going back into session? Thank you both for being here today. All right, back in the session. Members, do we have any questions for Representative Salinas? Seeing none, any objections to the question? Representative Salinas, you're recognized.
I just wanted to express my gratitude to the family and to the members of the committee. This is a bipartisan effort. We have over 30 people sign on. And as I was working the bill, I got to hear some of the stories from members. I know Representative Russell has a story, Representative Littleton has a story. And hearing the concern that y'all have for your constituents, it really restored some hope in the process for me. So thank you for that.
Thank you, Representative Salinas. Members, any questions for the sponsor? Seeing any objection to the question? Madam Clerk, if you'd open the board. Members, we're going to be voting to send House Bill 2606 as amended to Finance, Ways and Means. All those in favor vote aye. Opposed vote no. Has every member voted? Any member wish to change the vote? Madam Clerk, if you take the vote.
Mr. Chair, you have 17 ayes, 0 noes, and 0 present not voting.
Very good. Members, House Bill 2606 as amended is moving to Finance, Ways and Means. Members, that brings us back to item 28. That's House Bill 1354 by Chair Lady Littleton. Members, I'm looking at House Amendment 15385.
That's correct.
Very good. Members, any objections to adopting House Amendment 15385 to House Bill 1354? Seeing none, all in favor say aye. Aye. Opposed say no. Ayes have it. Now we're back on the bill as amended, and Chair Lady Littleton, you're recognized.
Thank you, Mr. Chairman. This bill does two things. The first part of the bill is a human trafficking bill. It creates a defense for an individual who is a victim of human trafficking and uses force intended to or likely to cause death or serious bodily injury against the person committing or attempting to commit the human trafficking offense against the victim. The second part of this bill generally prohibits the release of a person arrested for the offense of obstructing a passageway for 12 hours from the time of the arrest.
Thank you for that explanation. Members, any questions for Chair Lady Littleton? All right, any objection to the question? All right, seeing none, Madam Clerk, if you'd open the board. Members will be voting to send House Bill 1354 as amended to calendar and rules. All those in favor vote aye, opposed vote no. Several members voted, any members change the vote?
I guess I should vote aye.
All right, Madam Clerk, you take the vote.
Mr. Chair, you have 14 ayes, 1 no, 1 present not voting.
Very good. Members, House Bill 1354 as amended, moving to calendar and rules. Members, without objection, we want to roll the next item, 29, House Bill 1455 to the hill of this calendar. Without objection. That brings us to item 30. That's House Bill 1787 by Chair Lady Littleton. And members, I'm looking at House Amendment 13812.
That's correct.
Correct. Very good. Members, any objection to adopting House Amendment 13812 to House Bill 1787? All those in favor say aye. Aye. Opposed say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized.
Thank you, Mr. Chairman. This bill, as amended, it was brought to me by the TBI. The bill simply seeks to clarify current penalties in the law related to when an individual attempts to purchase a sex act from a minor, a person with an intellectual disability, or a law enforcement officer posing as a minor. It's long been the desire of the legislature to have the conduct punished as human trafficking, but this bill takes the punishments currently listed in the Human Trafficking Code and lists them under the patronizing code to help eliminate any confusion.
Very good. Members, you've heard the explanation. Any questions for the sponsor? Representative Johnson, you're recognized.
So this doesn't change anything in the code, correct?
Chair Lady Littleton.
That is correct.
Thank you.
Very good. Members, any additional questions for the sponsor? Seeing none, any objection to the question? Seeing none, Madam Clerk, if you'd open the board. Members, we voted to send House Bill 1787 as amended to calendar and rules. All those in favor vote aye. Opposed vote no. Has every member voted? Has every member wish to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 15 ayes, 0 noes, 2 present not voting.
Very good. Members, House Bill 1787 is moving to calendar and rules. And that brings us to item 31. That's House Bill 2013. Got a motion and a second, and I'm looking at 2 amendments there. Chair Lady Littleton, I've got 15388, and then the latest one is 16763.
I'd like to put both of them on, please.
Okay, members, let's, all those in favor Any objection in adopting House Amendment 15388 to House Bill 2013? Seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. And members, also, any objection to adopting House Amendment 16763 to House Bill 2013? Seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. And without objection, we're going to roll both those amendments into one, and you are properly recognized.
Thank you, Mr. Chairman. This expands the definition of a mass shooting for the purpose of requiring a decedent's blood to be tested for the presence of psychotropic drugs to include any shooting resulting in 4 or more individuals sustaining injury. Number 2, a shooting in which a reasonable person could conclude that the decedent attempted to kill 4 or more individuals.
Very good, members. You've heard the explanation. Any questions for the sponsor? Representative Johnson, you're recognized.
Thank you. Just a question. If the parent consents and say it's a teen or an older teenager, if the parent consents but the kid does not consent, will they have to forcibly take the test, or how will that work?
Charlie Littleton, you're recognized.
Thank you, Mr. Chairman. If it's a minor child, then the parent can. Consent.
Yes, the parent consents, but say it's a 17-year-old or a 16-year-old and they don't agree with that. Are they going to be forced to take the test or held, or what would that look like?
Charlie Littleton.
If they're a minor, which a 17 or 16-year-old would be.
So they'll be forced is what I'm asking.
Yes.
Okay.
Very good. Any additional questions for the sponsor? Seeing none, any objection to the question? Seeing none, members, we will be voting to send House Bill 2013 to, as amended, to calendar and rules. All those in favor vote aye. If you'd open the board, ma'am. Opposed, vote no. Has every member voted? Any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chair, you have 13 ayes, 2 noes, 2 present not voting.
Very good. House Bill 2013 as amended, moving to calendar and rules. That brings us to item 32 with Charlie Littleton as well. House Bill 2079. You got a motion in a second. I'm looking at House Amendment 15666.
That's correct.
Members.
Motion.
We got a motion in a second. Members, any objection to adopting House Amendment 15666 to House Bill 2079? Seeing none, all in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back in the bill as amended, and you're properly recognized.
Thank you, Mr. Chairman. As amended, House Bill 2079 creates an e-felony for anyone who intends to influence the outcome of an event which, while financially benefiting from the prediction market contract tied to the event. Prediction markets are increasing in the popularity nationwide, and while the contracts are regulated at the federal level, states must act early to protect citizens from potential manipulation.
Very good. Members, you've heard the explanation. Any questions for the sponsor? Seeing none, any objection to the question? Seeing none, Madam Clerk, you'd open the board. Members, we're going to be voting to send House Bill 2079 as amended to Finance, Ways and Means. All those in favor say aye, or excuse me, vote aye. Opposed, vote no. Has every member voted? Any member wants to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 17 ayes, 0 noes, 0 present not voting.
Very good. Members, House Bill 2079 as amended is moving to Finance, Ways and Means. That brings us to item 33. That's House Bill 2081 by Charlie Littleton. You've got a motion in a second. And Charlie Littleton, I see 2 amendments here. The latest amendment is 16935.
That's correct.
Very good. You got a motion in a second. Members, any objection to adopting House Amendment 16935 to House Bill 2081? Seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Mr. Chairman. This bill came from the Second Look Commission. I want to try to read what the Second Look Commission is, and then I'll proceed with the bill if that's okay. The bill arrived from a year-long finding from the Second Look Commission, a department of the Tennessee Commission on Children and Youth. I am one of the 4 legislative members on the commission, along with Senator Jackson, Senator Powers, and Representative McKenzie. The commission was created in response for the need to review and improve how the state handles severe child abuse cases. We meet along with child counselors, judges, law enforcement, and Department of Children's Services each month to conduct a deep dive investigation into these particularly chosen cases. This bill I bring today is a result of some of the issues and roadblocks we found that have resulted in legislation that will help the Department of Children's Services and the Tennessee Commission of Children and Youth to do their job and protect severely abused children. So what it does is it adds 2 members to the Second Look Commission, the Commissioner of Mental Health or her designee, and 1 member at large with experience of advocating for children. It authorizes the commission to request data and information from the representative involved in services of dependent and neglected youth. It changes the yearly date of the second look. It expands the definition of severe child abuse to include strangulation and expands the criteria of the offenses of aggravated child abuse, aggravated child neglect, and aggravated child endangerment to include abuse, neglect, and endangerment that involves strangulation. It authorizes a court to order a child's parent or guardian to submit documentation of compliance with preventive pediatric care until the child reaches 1 year of age, and to submit to a drug testing at regular intervals if the child who is under 1 year of age has been found to be dependent and neglected and diagnosed by a licensed physician with neonatal abstinence syndrome. Lastly, this bill authorizes the Department of Children's Services to initiate a visit to ascertain a well-being of the child if the documentation provided contains allegations of abuse or neglect.
All right, members, you've heard the explanation. Any questions for the sponsor? Representative Johnson, you recognize.
Yes. Now, does this bill include how they call the cases to decide what they're looking at? It's my understanding it's sort of moved from outside sources to DCS is going to make that decision. And is that correct?
Chairlady Littleton.
Thank you, Mr. Chairman. None of that has changed than what was already ordered other than what I read.
Very good. Any additional questions?
Yeah, I guess it has come to my attention that some of the same people won't be looking at what is heard, and that is my concern. But thank you.
Very good. Chairlady Littleton, you recognize.
Thank you, Mr. Chairman. What we've did is we've overlooked some of the rules that were already in the first bill for the second commission, and we're going back to what that says. So we haven't changed anything.
Very good. Any follow-up? All right. Representative Travis, you recognize.
Thank you, Mr. Chairman. Move previous question.
Very good. Question's been called. Any objection to the question? Seeing none, Madam Clerk, if you open the board, members will be voting to send House Bill 2081 as amended to GovOps. All those in favor vote aye. Opposed, vote no. Has there been voted? Any member wish to change the vote? Madam Clerk, will you take the vote?
Mr. Chair, you have 14 ayes, 1 no, 2 present not voting.
Very good. Members, House Bill 2081 as amended is moving to GovOps. That brings us to item 34, House Bill 2349 by Chairlady Littleton. You got a motion and a second looking at House Amendment 15638. That's it. Members, any objection to adopting House Amendment 15638, House Bill 2349? Seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Mr. Chairman. This bill as amended requires the Department of Children's Services on or before July the 1st, 2027 to establish a well-based system through which the members of the public may obtain a list of all licensed and approved child care agencies searchable by zip code. Requires the website to list the agency's license status, information concerning an adverse licensing action toward against an agency, information concerning agency inspections, and other relevant information. Directs DCS to post full monitoring and inspection reports and to include a minimum of 3 years of inspection reports where applicable.
Very good, and thank you for that explanation. Any questions for the sponsor? Seeing none, any objection to the question? Seeing none, Madam Clerk, if you'd open the board, members will be voting to send House Bill 2349 as amended to Finance, Ways, and Means. All those in favor vote aye, opposed vote no. Has every member voted? Any member wish to change the vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 17 ayes, 0 no, 0 present not voting.
Very good. House Bill 2349 as amended is moving to Finance, Ways, and Means. And that brings us to item 35, House Bill 2354 by Chairlady Littleton. You're properly recognized.
Thank you, Mr. Chairman. This bill prohibits probation for any person convicted of sexual battery by an authority figure.
Very good. You've heard the explanation. Any questions? Seeing none, any objection to the question? Seeing none, Madam Clerk, if you'd open the board, members will be voting to send House Bill 2354 to Finance, Ways, and Means. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member wish to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 18 ayes, 0 noes, 0 present not voting.
Very good, members. House Bill 2354 as amended, House Bill 2354 is moved to Finance, Ways and Means. Members, we could move without objection to item 52. Representative Stevens is sitting there. That's House Bill 1967. And sir, I'm looking at two amendments. The latest amendment is 16903.
That's the one we'd like to use.
We get a motion and a second. Members, any objection to adopting House Amendment 16903 to House Bill 1967? All right, seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. You're probably recognized, sir.
Thank you, Mr. Chairman. The past few weeks, I've been working with a constituent on a hit and run bill. This is a big problem. The bill that we presented last week increased the penalty for the hit and run cases one step, whether it's an injury or a death. And the fiscal note on that is almost insurmountable. So this bill is kind of a pared back version of that deals with the cases where there is a death from the hit and run case. And basically, the person that commits this offense will get no less than 1 year in prison. It still will be a Class C felony, but they will have a minimum 1 year sentence and then a fine of no less than $5,000, but no more than $10,000.
Very good, members. You've heard the explanation. Any questions for the sponsor? All right, Representative Salinas, you're recognized.
I know there was another bill that was similar to this. How is it different?
Representative Stevens.
Thank you, Mr. Chairman. That was my bill last week. So right now it's a Class A misdemeanor to be involved in a hit and run case where there's an injury, and a Class C felony if it's a death. And my bill, the other bill, increased each of those by one step. So it went from a Class A misdemeanor to a Class C felony for the hit and run with an injury, and a Class E felony to Class D felony for cases involving a death. The fiscal note on that came back over $1 million. This one has a much more feasible fiscal note. The difference is that it's the minimum sentence for someone that's involved in a hit and run with a death.
Representative Salinas, any follow-up?
Yeah, and then I know Chairman Farmer had one. How is this one different than that one? Do you know?
This is my bill. I'll sign it over to him.
Got it.
It is. There you go.
That's why I was like, there's no difference.
Thank you for the questions. Representative Johnson, you're recognized.
Thank you. And thinking about things I've seen where there's in the middle of a protest and someone hits a protester, typically they take off. And, maybe they're afraid of stopping in the middle of all these people, that sort of thing, but that's going to count for them as well, correct? Regardless of why you leave the scene.
Representative Stevens, you recognize.
That is correct. If you hit someone and drive off and that person dies, then this would cover you.
Thank you.
Because I believe you had a family you're working on behalf of some of your constituents on this. I know
That's
you're
correct.
passionate about it, and Representative Stevens and I got together and realized that it was the right thing to do for his constituents to be sure we got something across. He got something across the finish line. So, members, any additional questions? Seeing none. Any objection to the question? Seeing none, Madam Clerk, you'd open the board. Members, we voted to send House Bill 1967 as amended to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Is there a member voting? Member wants to change the vote? Madam Clerk, take the vote.
Mr. Chair, you have 18 ayes, 0 noes, 0 present not voting.
Very good. House Bill 1967 as amended is moving to Finance, Ways and Means.
Thank you.
Thanks, sir. All right, members. If we could, without objection, let's go back to item 36. Chairman Doggett. House Bill 489, you've got a motion and a second, sir. I'm looking at House Amendment 16128. You got a motion and a second. Members, any objection to adopting the House Amendment 16128, House Bill 489? Seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Chairman Doggett, you're probably recognized as amended on the bill.
Yes, sir. Thank you, Mr. Chairman. This bill, as amended, creates statewide standards for handling the non-payment of court-ordered transdermal alcohol monitoring devices by non-indigent defendants.
Members, you've heard the explanation. Any questions from the sponsor? Representative Johnson, you're recognized.
Yeah, just one thing I wanted to check on. I've heard that this could be a pretty big volume item, and are jails aware, and are they ready to overcome, what could potentially be, adding a lot more folks to their numbers?
Chairman Doggett.
Thank you, Mr. Chairman. Thank you for the question. We're not seeking to incarcerate folks here. This is something that everything else that we have done when it comes to the monitoring services that are court ordered, there's always been some type of mechanism that takes place there. So basically, we're requiring 24-hour notice to supervising authorities before the monitoring is terminated, and those things. So it's not intended to penalize indigent defendants, remove judicial authority discretion, create automatic sanctions, or increase any incarceration.
Very good. Any
Thank you.
additional
I
questions?
understand it's not intended to, but I'm wondering if that might be a potential.
Chairman Doggett.
That would be, that would come back to a judge to make that determination if they did want to incarcerate them. But from the fiscal note that we received back, there was no local increase for jailing on this.
Very good. Members, any additional questions for the sponsor? Seeing none, any objections to the question? Madam Clerk, if you'd open the board, members will be voting to send House Bill 489 as amended to calendar and rules. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member wish to change the vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 19 ayes, 0 noes, 0 present not voting.
Very good, members. House Bill 489 as amended is moving to calendar and rules. Members, without objection, we are going to back up to item 4, House Bill 1816. I saw Chairman Williams, he's arrived. So you got a motion and a second. I'm looking at, I see 2 amendments. Your latest amendment is drafting code 16916.
Thank you, Chairman. At this moment, I think that thing is not fully cooked. So I'm just going to stick with the amendment that came out of subcommittee, drafting code 1016916.
Very good. We'll stick with drafting code 016916. You got a motion and a second. Members, we want to go ahead and adopt House Amendment 016916 to House Bill 1816. All those in favor say aye. Aye. Opposed say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Chairman and members. This bill ensures Tennessee is using its opioid abatement settlement dollars as intended to address the addiction and mental health crisis across the state. It represents a targeted statewide investment in these critical services, especially mobile crisis response units, which are serving our citizens all across the state, where timely care is essential for individuals with co-occurring mental health and substance use disorders. We also face a serious shortage of residential treatment beds with wait lists in Middle Tennessee, limited capacity in West Tennessee, and a growing strain on the services in East Tennessee. Other states are prioritizing these same investments, and that's what this bill does. It utilizes those dollars in a way that the Tennessee General Assembly sees fit. Chairman and members, I'm happy to answer any questions you might have.
Very good. Members, you've heard the explanation. Any questions for Chairman Williams? Representative Johnson, you recognize.
Thank you, Mr. Chairman. And my question with these is always, I think that prevention is really important. And I feel like sometimes because we're in the situation with so much addiction that we have, we're very heavily weighted to current treatment. But is there any percentage of this money that is allotted for prevention?
Chairman Williams.
The goal is to deal with both prevention and treatment with this bill. It really depends on how those monies are distributed, obviously, and there's a concerted effort to try to do it in that way here.
Thank you.
Thank you.
Very good, members. Any additional questions for the sponsor? All right, seeing none, any objection to the question? Seeing none, Madam Clerk, you open the board. Members will be voting to send House Bill 1816 as amended to Finance, Ways and Means. All those in favor, vote aye. Opposed, vote no. Has every member voted? Any member wish to change the vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 19 ayes, 0 noes, 0 present not voting.
Very good, members. House Bill 1816 as amended is moving to Finance, Ways and Means.
Thank you, Chairman.
Thanks, sir. All right, members, if we could go back to item 37, that's House Bill 1273 by Chairman Doggett. So you got a motion in a second. I'm looking at House Amendment 15796. You've got a motion in a second. And members, do we want to go ahead and adopt House Amendment 15796 to House Bill 1273? Any objections? Seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Mr. Chairman. This is adding, it clarifies that only credible threats must be reported to law enforcement when it comes to threats of mass violence dealing in schools.
Very good, members. You've heard the explanation. Any questions for the sponsor? Seeing none, any objection to the question? Seeing none, Madam Clerk, you can open the board. Members, we're going to be voting to send House Bill 1273 as amended to calendar and rules. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member to change the vote? Very good, Madam Clerk, you take the vote.
Mr. Chair, you have 16 ayes, 0 noes, 2 present not voting.
Very good. House Bill 1273 as amended is moving to calendar and rules. That brings us to item 38. That is House Bill 2367 by Chairman Doggett.
Motion.
Very good. And you're properly recognized, sir.
Thank you, Mr. Chairman. This bill has does four things. It's part of a victims package. It amends current law related to the separation and exclusion of witnesses to enforce victims' rights to be present at all proceedings. Designates a law enforcement agency that expends funds for the purchase of controlled substances and or contraband would be eligible as a victim to receive restitution for the funds. It also expands criminal injuries compensation statute to include eligibility for victims of evading arrest in motor vehicles resulting in bodily injury or death or vehicular homicide. And it also adds victim to the list of individuals involved in the judicial purposes for the retaliation of a past action.
Very good. And thank you for that explanation. Any questions for the sponsor? Representative Johnson, you're recognized.
Thank you. My question is, does this add the ability for insurance companies to get money out of the victims' funds as well?
Chairman Doggett.
Is my understanding.
That is not a part of this bill, no ma'am.
Okay, but it does allow law enforcement. My concern is that this is a victim fund, and it's kind of the average victim really doesn't always know how to access this fund. But I just have concerns where law enforcement agencies are getting funds out of it that really is meant to go to victims, and I guess that's my concern.
Chairman Doggett, any follow-up?
Yes, thank you, Mr. Chairman. So the reason why this is in there is that law enforcement agencies across the state have spent thousands of dollars as a part of an investigation buying drugs or contraband, controlled substances as a part of that. When it goes to court, if restitution is not ordered, there's no mechanism for those departments or agencies to get those funds back. And so a lot of times you have these defendants running around living off of the proceeds of our agencies that were used as a part of that investigation. So there was a court case in State versus Graves that we needed to bring some clarification to show that these department and agencies could be defined as victims to get those funds back if restitution was not ordered.
Very good. Members, any additional questions for the sponsor? Seeing none, any objection to the question? Seeing none, Madam Clerk, would you open the board? Members, will be voting to send House Bill 2367 to Finance, Ways and Means. All those in favor, vote aye. Opposed, vote no. Has every member voted? Does any member wish to change the vote? Madam Clerk, take the vote.
Mr. Chair, you have 17 ayes, 1 no, 1 present not voting.
Very good. House Bill 2367 is moving to Finance, Ways and Means. And that brings us to item 39. That's House Bill 2368 by Chairman Doggett.
Second.
And then the latest amendment I'm looking at is 16539.
Yes, sir.
Very good, members.
Second.
Got a motion and a second. Any objection to adopting House Amendment 16539 to House Bill 2368? Without objection, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now back in the bill is amended, and you're probably recognized.
Thank you, Mr. Chairman. This bill is amended. Current law states it's already illegal to fly a drone over a ticketed event or like a concert or a sporting event. And this amendment expands that prohibition to 400 feet beyond the walls of the event.
Members, any questions for the sponsor? Any objection to Representative Johnson? You're recognized.
Yeah, just quick. I was wondering what the impetus for the bill was and maybe an example of what this would look like.
Chairman Doggett.
Basically for public safety purposes, safety of those that are in the event, those that are there. We live in a time, unfortunately, where individuals could use drones to see how many people are in a facility, to look for exits, entry points, different things. And so this is what that is for. Only those that are authorized to utilize those drones in those areas will be permitted, but anyone else. It prevents someone from setting up in a park across from a concert and watching individuals, the flow of foot traffic in and out, things like that. So purely for public safety.
Very good. Any follow-up? Any additional questions for the sponsor? Seeing none. Any objection to the question? Seeing none. Madam Clerk, would you open the board? Members will be voting to send House Bill 2368 as amended to calendar and rules. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member wish to change the vote? Madam Clerk, take the vote.
Mr. Chair, you have 18 ayes, 0 noes, 0 present not voting.
Very good. House Bill 2368 as amended is moving to calendar and rules. That brings us to item 40, House Bill 2369.
Second.
By Chairman Doggett, you got a motion and a second. The latest amendment I have is 16844.
That is correct.
Very good. Members, any objection to adopting House Amendment 16844 to House Bill 2369? All those in favor say aye. Opposed say no. Ayes have it. Now back on the bill as amended, and you're probably recognized.
Thank you, Mr. Chairman. This bill does two things. One, it requires the municipality to pay the cost of an autopsy if the autopsy is requested by the municipality or their municipality law enforcement police department, unless the autopsy is paid for by the state, and then it increases the maximum monthly fee related to probation and judicial diversion for eligible defendants to $60.
Very good. Members, any questions for the sponsor? Any objection to the question? All right, Madam Clerk, you open the board. Members will be voting to send House Bill 2369 as amended to Finance, Ways and Means. All those in favor vote aye. Opposed vote no. Every member voted. Any member wish to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 15 ayes, 4 noes, 0 present not voting.
Very good. House Bill 2369 as amended is moving to Finance, Ways and Means. That brings us to item 41, House Bill 2374. So we got a motion and a second. You're probably recognized.
Thank you, Mr. Chairman. This is something we've worked on for several years now with the failure to appear and having those defendants that are charged with certain crimes being entered into national databases such as NCIC. Current law states the sheriff or the entering agency has 3 days to enter these warrants. We are expanding that to 10 days.
Very good. Members, you've heard the explanation. Any questions for the sponsor? Seeing none, any objection to the question? Seeing none, Madam Clerk, if you'd open the board, members are going to be voting to send House Bill 2374 to calendar and rules. All those in favor vote aye. Opposed vote no. Is there a member voted? Any member wish to change the vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 19 ayes, 0 noes, 0 present not voting.
Very good. House Bill 2374 is moving to calendar and rules. And that brings us to item 42, House Bill 2377. By Chairman Doggett, you got a motion and a second. You're probably recognized.
Thank you very much, Mr. Chairman. This bill deals with the continuous sexual abuse of a child statute. Current statutory time frame that's on there is 90 days. We're reducing that down to 30 days.
Very good. Members, any questions for the sponsor? Any objection to the question? Seeing none, Madam Clerk, if you'd open the board. Members are going to be voting to send House Bill 2377 to Finance, Ways and Means. All those in favor vote aye. Opposed vote no. Has that member voted? Any member wish to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 19 ayes, 0 noes, 0 present not voting.
House Bill 2377 is moving to Finance, Ways and Means. And that brings us to item 43. That's House Bill 2480 by Chairman Doggett. So we got a motion and a second. You're probably recognized.
Thank you very much, Mr. Chairman. This bill would replace 5 grant-funded social worker positions with the Tennessee District Public Defenders Conference. Those positions are set to expire this year with permanent state funding positions in judicial districts 1, 7, 12, 22, and 29. So we're just asking to fill those grant funding positions that are going to expire this year with 5 social worker positions.
Members, any questions for the sponsor? Any objection to the question? Seeing none, Madam Clerk, you'd open the board. Members are going to be voting to send House Bill 2480 to Finance, Ways and Means. All those in favor vote aye. Opposed vote no. Has every member voted? Would any member wish to change the vote? All right, Madam Clerk, if you'd take the vote.
Mr. Chair, you have 19 ayes, 0 noes, 0 present not voting.
House Bill 2480 is moving to Finance, Ways and Means. That brings to item 44. That's Senate Joint Resolution 28 by Chairman Russell. You got a motion and a second. You're probably recognized.
Thank you, Mr. Chairman. Committee, House or Senate Resolution 28 is a bipartisan resolution that supports the bipartisan constitutional concealed carry reciprocity act and the 119th U.S. Congress with more than 120 co-sponsors. If passed, at the federal level, it would provide a nationwide reciprocity for a concealed carry license holder and for residents of constitutional carry states. Without, I renew my motion.
Members, any questions for the sponsor? Any objection to the question? Seeing none, Madam Clerk, you'd open the board. Members are going to be voting to send the Senate Joint Resolution 28 to calendar and rules. All those in favor vote aye. Opposed vote no. Has every member voted? Any member wish to change the vote? All right, Madam Clerk, take vote.
Mr. Chair, you have 14 ayes, 5 noes, 0 present not voting.
Very good. Senate Joint Resolution 28 is moving to calendar and rules. Members, that brings us to item 45. That's House Bill 1254 by Representative Alexander. And we've got a motion and a second, and
Thank you,
you're probably
Chairman.
recognized.
Thank you, Chairman. Thank you, committee. This bill just gives due process to our police officers. It allows them some way to go when someone accuses them of something and puts them on a Brady letter that can run their career for the rest of their lives. I've worked with sheriffs and police, with the DA's conference, and with public safety or Tennessee safety on this. And this is what we have landed on.
Very good, members. You've heard the explanation. Any questions for the sponsor? Seeing none, any objection to the question? Seeing none, Madam Clerk, would you open the board? Members, we're voting to send House Bill 1254 to calendar and rules. All those in favor vote aye. Opposed, vote no. Has every member voted? Any members change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 16 ayes, 0 noes, and 2 present not voting.
Very good. House Bill 1254 is moving to calendar and rules. That brings us to item 46. That is House Bill 1525 by Representative Stinnett, and you're probably recognized.
Thank you, Chairman. I do have a, should be 009948. No. Excuse me, I'm incorrect. I'm good to go.
Very good. You're probably
Thank you,
recognized.
sir. The only thing worse than victimizing a child is victimizing multiple children at this, in the same section. And Tennessee Code addresses criminal sentencing enhancement in cases where the victim of a crime is a minor under the age of 18. By adopting this proposal, 4035-115, it would add to this section that if a defendant is convicted of 2 or more offenses involving multiple victims who are minors under the age of 18 at the time of the commission of the offense, the judge would have the could apply consecutive sentencing. So instead of, if it was 4 kids, instead of 2 years, the judge, if he felt that it was needed, he could sentence the person to 8 years. I stand for questions.
Very good, members. You've heard the explanation. Any questions for the sponsor? Representative Johnson, you're recognized.
Thank you. So this isn't an automatic, but what this bill does is it allows for judicial discretion. Is that correct?
Yes, ma'am.
Thank you.
Okay. Members, any additional, Representative Ashley, you recognized.
Stand for
Previous question.
Very good. Questions be called. Members, any objection to the question? Seeing none. Madam Clerk, you'd open the board. We're voting. We're going to be voting to send House Bill 1525 to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Has everyone voted? Any member wish to change the vote? All right, Madam Clerk, you take the vote.
19 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 1525 is moving to Finance, Ways and Means. That brings us to item 47. That's House Bill 1538 by Representative Stinnett. You've got a motion and a second. You probably recognize on the bill. I'm looking at Amendment 14528, sir.
Yes.
Members, any objection to adopting House Amendment 14528 to House Bill 1538? Seeing none, all those in favor say aye. Aye. Say no. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Chairman. While Tennessee Department of Corrections have made progress in reducing contraband into our prisons, we're beginning to have problems with drones dropping telephones and drugs into our prisons. What this 1538 would do, it would allow state prisoner guards to legally take down the drones. I stand for questions.
Good members, you've heard the explanation. Any questions for the sponsor? Representative Johnson, you're recognized.
Yes, I'm curious how often we're seeing this in Tennessee. And I guess my other question for curiosity is a significant amount of contraband actually is brought in by prison guards. So what is the penalty for a prison guard who brings in contraband? Do we need to ask
Ma'am.
legal?
Representative Stinnett, would you like to be recognized?
Yes, this doesn't, this bill has nothing to do with prison guards.
That's right. There's current law that covers prison guards.
Yeah, I'm aware of that. That's what I'm curious about, how this penalty is different from the penalty for a prison guard who brings in contraband. So I guess maybe we need to ask legal what that penalty is.
Not, Chairman, I'm not,
Representative Stinnett, you're recognized.
Chairman, I'm not for sure what that has to do with passing this bill.
I'm looking for parity. I want to see.
If you just wait to be recognized, I'll recognize you. Representative Johnson, you're recognized.
Sorry, sir. What I want to see, what the difference is. Is it the same penalty for each of those things is my curiosity, because we know that a very significant amount is brought in that way. And so for me on this vote, what I'd like to know, is there a difference in those two penalties?
Okay, members, without objection, go to the session. We're going to recognize Michelle Fogarty with Legal Services.
Michelle Fogarty, Legal Services. So if you bring a contraband that is a weapon, ammunition, or explosive, then it's a Class C felony. If it is an intoxicant, a legend drug, a controlled substance, then it's a Class D felony. And if it's a communication device, it's a Class E felony.
Any additional questions, Representative Johnson?
No, I think that's got it. There is a difference in the level. So thank you.
You're welcome. Members, any additional questions for legal while we're out of session? All right, seeing none. Any objection to going back into session? Seeing none. Any additional questions for the sponsor? Seeing none. Any objection to the question? Seeing none, Madam Clerk, you'd open the board. Members are going to be voting to send House Bill 1538 as amended to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Has everyone voted? Any member wish to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 18 ayes, 0 noes, and 1 present not voting.
Very good. Members, House Bill 1538 as amended is moving to Finance, Ways and Means. And that brings us to item 48. That's House Bill 2296. That's by Representative Hardaway. Looks like it's general sub in the Senate. Sir, what would you like to do with that?
Mr. Chairman, once we move, they will move.
Without objection, we'll roll this to Hill of today's calendar. Item 49, that's House Resolution 143 by Representative Johnson.
Motion.
Second.
And you've got a motion and a second. You're probably recognized.
Thank you, Mr. Chair. What this resolution does is honor the life of Dr. Ashley McKenzie, lovingly called Dr. M by her students. Dr. M was a professor of sociology on women's and gender studies at MTSU, and I brought this resolution because she was my assistant professor, academic mentor, and thesis advisor during her sociology master's program. Here are some words Kelsey asked me to share about Ashley. Even before I started my master's program, Dr. Ashley McKenzie already made an impact on my life. In undergrad, she was the professor that opened my eyes to sociology and taught me topics that still stick with me today, specifically regarding racial and gender inequalities. Dr. M taught my first graduate class and welcomed me to the program with open arms, offering her free time to help me with the thesis research and just being there for anything I needed. We grew very close throughout the 2 years I was in the sociology's master's program, even traveling together to attend conferences. Words cannot measure the profound impact she's had in my life, not just academically, but personally. Yes, she's taught me so much about sociology and social research in general, but she also showed me the importance of mentorship. She inspired me to extend my career in academia, and as I am also currently an adjunct professor of sociology at MTSU. And I'm trying to continue her legacy by treating her students the way she treated me. She never hesitated to go out of her way to help me with anything, and that made me feel so special. Once Dr. M told me that her favorite part of her job was advising students, and it showed. I just hope I can honor her life and service to her students by passing this resolution. Additionally, the Sociology and Women's and Gender Studies departments are excited about getting this resolution passed, as they want Dr. M to be honored the way she deserves.
Members, you've heard the explanation. Any questions for the sponsor? Leader Lambert, you recognize, sir.
Thank you, Mr. Chairman, and I know I've shared my concerns with the sponsor of the resolution. It's still an open investigation. I'm not going to vote against it out of respect for her family and the fact she is deceased. I chose just present not voting in sub, and I'm going to do the same thing today. I respect her life and legacy. I just wish we had a resolution to the actual criminal investigation so that we knew what happened. And I'm confident that the folks at MTSU and throughout Tennessee that are fans of hers, I'm sure want that resolution. And I'm asking law enforcement to rapidly finish that up and efficiently and effectively, of course. But I think all of us would like to see what happened there and let justice be done no matter what occurred. So that's just my concerns. And I've shared them before. I just want to share them today.
Yes, and thank you for that. But, you know, we most know how long murder investigations can last. There was a resolution on someone who was murdered last year that we went ahead and passed, and that investigation is still open, sadly. So I just ask for passage. Thank you.
Very good. Members, you've heard the explanation. Any additional questions for the sponsor? Seeing none, any objection to the question? Seeing none, Madam Clerk, you open the board. Members, we're going to be voting to send House Resolution 143 to calendar and rules. All right, Madam Clerk, take the vote.
Mr. Chair, you have 6 ayes, 4 noes, and 9 present not voting.
Very good. House Resolution 143 moves to calendar and rules. That brings us to item 51. Chair Lady, Vice Chair Davis, would you knock that out for me?
All right. All right, members, we have House item number 51, House Bill 1962 by Chairman Farmer. I don't see any amendments on the bill. Sir, you're recognized on your bill.
Very good, members. What this bill does, right now there is a presumption that under any circumstance that a defendant, there's a presumption of, if a defendant is charged with aggravated assault, which is a C felony, there's a presumption of probation. This would change the law to say that if a firearm is used, that presumption goes away. And that's what this bill does.
All right, members, do we have any questions for the sponsor? Otherwise, any objection to the vote? All right, Madam Clerk, will you open the board for the vote, please? All those in favor vote yes. Those opposed vote no. Has everyone voted? Does anyone wish to change their vote? Madam Clerk, will you take the vote?
Madam Chair, you have 17 ayes, 1 no, and 1 present not voting.
All right, House Bill 1962 passes and moves to Finance, Ways and Means.
Very good. And that brings us to item 53. That's House Bill 2501. That'll be taken off notice without objection. And that brings us to item 54. That's House Bill 2526. Got a motion in a second. I'm looking at House Amendment 14717.
That's correct.
Very good. Members, any objection to adopting House Amendment 14717 to House Bill 2526? All right, seeing none, all in favor say aye. Aye. Opposed say no. Ayes have it. Now we're back on the bill as amended. And Charlie Littleton, you're properly recognized.
Thank you, Mr. Chairman. This bill as amended establishes a juvenile commitment review task force to make findings and recommendations in regards to the placement of children committed to DCS custody as dependent and neglected with violent behaviors, many of whom with pending serious delinquent charges. The task force will be composed of representatives from the DCS Department of Mental Health, Substance Abuse, and the Department of Disability and Aging, the Commission on Children and Youth, the Council of Juvenile and Family Court Judges, the District Public Defenders Conference, and Guardian ad litem, and several others. Secondly, the bill amends TCA 37-137B1D to add to determinate 6-month extension to its use commitment if the youth assaults a staff member while in DCS care. This will only apply to the youth already adjudicated delinquent under the health and safety exceptions. The amendment ensures that the juvenile court plays a role in the process and children have an appropriate due process.
Very good, and thank you for the explanation. Members, any questions for the sponsor? Representative Johnson, you recognize.
I feel like it is unclear on the due process portion. A judge can look at the assault that's accused, but there's nothing that indicates that the child has legal assistance and that they got to speak on the assault and got due process there. So that is one of the things that concerns me about this legislation.
Members, we do have two folks that signed up to speak, so at any point in time, Chair Lady Littleton, if you'd like to go out of session and hear from those, we can do so.
Sure, thank you.
Representative Keesling, you're recognized.
Thank you, Chairman, to the sponsor. Now, we're creating, of course, I see them in the task force. Is that all we're doing, sponsor?
Chair Lady Littleton, you're recognized.
No, it does several things.
Well, okay, with that, if I may.
Yes, Representative Keesling, you're recognized, sir.
So I do know you went over you gave us an overview. So I was just thinking that this was just that the task force would be responsible for, I guess, creating or doing whatever we need to do they need to do. But anyway, with that, I appreciate it. Thank you, Chairman.
Very good. And I have Chairman Todd, you recognize?
Thank you, Mr. Chairman. I just wanted to ask, and this may have to be legal, I'm not sure, but does this specify what the standard for proof in the court would be? Preponderance of evidence or clear and convincing? What exactly would that standard be?
Members, any objection going out of session here from Legal Services? See none. Ms. Fogarty?
Michelle Fogarty, Legal Services. So the language in the bill says that the child does not have to have been adjudicated delinquent for the assault offense. So it just gives the court discretion to order the child to remain in custody for an additional 6 months if the court finds after a hearing or a stipulation that the court has committed an assault against a staff member at the child's residential placement.
Chairman Todd.
So would I assume that's a preponderance of evidence that they're utilizing in that process?
It doesn't specify that, but I would assume that if the court holds a hearing, they would have to make some sort of finding that an assault was committed, I would think.
Thank you.
Representative Powell, you recognize. Any questions for legal? Very good. Members, any additional questions for legal? Any objection going back in? Representative Salinas, you recognize for legal.
Oh, for legal?
Okay, yes.
Okay. I was just going to ask if there was anyone signed up to testify, that's all, since we are out of session.
That's right. Any objection, any additional questions for legal? All right, seeing none. Any objection going back into session? Seeing none. And we do have two folks signed up to testify, and members without objections go out of session to hear from them. That's Miss Jasmine Miller and Zoe Jamal. Ladies, I believe you've both been in committee rooms testifying before, so once your red light's on, please introduce yourselves, and you'll have 2 minutes apiece, and then we'll open it up for questions.
Hi, my name is Jasmine Miller, and I'm a senior attorney at Youth Law Center. We're a national nonprofit focused on child welfare and juvenile justice reform issues. There are two components to this bill, the 6-month sentence extension for delinquent youth and the task force addressing system issues and service gaps for dependent and neglected youth who may have externalizing behaviors. I'm concerned that the first part of this bill will actually exacerbate the problems that the task force part of the bill is meaning to address. So the portion of the bill bill about the 6-month sentence extensions would allow a youth sentence to be extended if there is an assault on staff at a residential placement. This is essentially redundant language because our current system allows treatment providers to recommend sentence extensions to the court if the youth needs treatment and services available only if they are in custody. Any behavioral incidents, including an alleged assault on staff, would already be taken into account in the treatment provider's assessment of a youth's progress. Given that treatment providers already recommend sentence extensions, the only use for this new provision would be to commit a youth for an additional 6 months to the custody of the department when the treatment provider has said that they don't think that that is necessary or appropriate. Let's walk through the consequences of what that would be. The treatment provider has already recommended to the court that they don't think that the youth needs their services. So they have two choices. One is to essentially babysit the child for another 6 months, which means that that bed, which is, by the way, $600 a day, is not available for another young person. The other would be to discharge the youth from their treatment program, which would put the youth back into the pool of children in temporary placements, which would be the offices, assessment centers, and transitioned homes, juvenile detention. Those are the types of settings that the task force is trying to address. So either of those outcomes directly would feed the problems that the task force aims to correct. And the fiscal note on this amendment is $4.6 million recurring. I'm not sure that that is a great way to spend that money. Also happy to touch on due process issues and definite issues if members have questions. I will also note that I have some concerns about the composition of the task force and whether it has the powers
your 2 minutes
necessary.
are up. Your 2 minutes are up. Thank you. All right. Zoe, Jamel,
Yes.
you're recognized.
Thank you for allowing me to speak and to the sponsors for facilitating meaningful feedback on this bill. I appreciate the ability to engage in important conversations about safe environments for youth in DCS custody. I renew my subcommittee testimony regarding due process issues arising out of the 6-month sentence extension. Bill language guaranteeing access to legal representation and an opportunity to refute with evidence a claim of staff assault would provide some much needed clarity. Process specificity is crucial because extending a sentence based solely on an alleged offense for which the youth is not adjudicated isn't an existing option in our code. So there's no guidance for what implementation looks like outside of what's written in the bill. My testimony today, though, focuses on how language requiring a court to make a finding about the appropriateness of a youth's residential placement prior to ordering the 6-month extension would meet another need for specificity in the bill. Concerns remain about the assault provision and its potential impact on youth who are housed in settings that cannot meet their needs, specifically disability needs, which makes them susceptible to abuse or neglect. When children are placed in residential settings that aren't equipped to serve them, it can breed conditions that may lead to behavior that would qualify as an assault. This kind of behavior is often communication, signaling that a child's needs aren't being met. Staff training on behavior intervention plans and de-escalation goes a long way toward preventing physical behaviors related to a child's disability in a way that provides safety for all. Oversight is crucial to ensuring placement appropriateness, service adequacy, staff training, and safety. So recent state-issued findings pointing to a lack of oversight in DCS-approved facilities lend credence to concerns about this bill. The 2025 Comptroller's audit found that the department was not investigating allegations of abuse and neglect. Another report noted the high occurrence of broken bones as a result of physical restraints. Tasser's 2026 study on juvenile detention centers acknowledged the need for additional oversight in residential facilities.
All right, Ms. Jamel, I'm sorry, your 2 minutes is up. Excuse me. Members, do we have any questions? Representative Johnson, you're recognized.
Thank you, Madam Chair. I've heard that other states have also had issues with hard-to-place youth lingering in temporary placements. What are some of the approaches? I think sometimes we continue to do the things that we've always done. So what are some approaches that have been taken by other systems that have been successful? Are you guys aware of any of those?
Yes, I'm happy to talk about Virginia. And so I know that there are two kind of different portions of this bill. So what I'm speaking about is most relevant to the bit about the task force, proposed task force. When Virginia had this problem around kids sleeping in offices, Governor Glenn Youngkin convened something called the Safe and Sound Task Force, which was able to cut the number of young people sleeping in offices by 89% in 90 days. They used rapid response interagency teams to assess assess youth and identify placement and service options, pulled data to better understand the population of children who are ending up in offices, many of whom were kids with disabilities, including mental health needs, also some young people who have some overlap with juvenile justice involvement. And crucially, they wanted to understand why those children were in the offices at all. And they were asking themselves, what would it take to meet each child's needs? And crucially, their top recommendation was about prioritizing the recruitment, retention, and the needs of relatives, kin, and foster parents. Okay, so they were really pushing on the idea that a lot of these young people who are described as hard to place, that it is feasible for some of those young people to be placed in the community. The population of young people that they were looking at in their task force is pretty much exactly the same as the population that we've been talking about here in Tennessee. And they've had a lot of success in recent years. They have more than doubled their rate of kinship foster placements. They've done a variety of different types of creative funding mechanisms, been doing some investments in behavioral and mental health to prevent entry. One thing I will note, while the legislation that is proposed today does propose a task force that has members from different agencies, which I do think is an important first step. There are a couple of differences between that the Virginia task force and the one that's proposed in Tennessee. The one in Tennessee, the fiscal note on that task force says that they anticipate that it will meet only 4 times, which seems like that might not be enough times to really get to the root of the problem. The task force proposed in Tennessee also isn't allowed to look at any records that could identify an individual. And so what that means is that they're not going to be able to engage in the kind of individualized analysis that you would really need to do in order to come up with service plans to close gaps for these young people. I'll also note that the task force here doesn't include any feedback from foster parents, caregivers, or former foster youth. So to the extent that there could be opportunities to expand family-based placement for at least some of these young people. I'm not sure that the task force as currently composed is really set up to look at that. And some of that may be related to the choice of language that was used in defining the task force, where they're focusing on this idea that it's about youth engaging in violent behavior that can constitute a delinquent offense. But I think what we know about a lot of these young people who are in the transition homes, who are experiencing really difficult conditions in the transition homes, many of them, again, have disability or mental health needs. And so because we're kind of talking about it as if these are pre-delinquent young people, I think it maybe has shaped the way that the task force is being talked about. I will also just note that there is a separate proposal that I believe y'all have already passed through the Department of Disability and Aging collaboration with DCS that would look at the needs of young people with intellectual and developmental disabilities. I think that is a really great step, and I'm just wondering how this legislation might potentially conflict with that legislation that has gone through about DDA, if you're talking about the same population, but kind of defining it in different ways. So anyways, that was my long answer to your question. There are solutions. I do want to say, because I know we talk a lot in various committees about DCS, about foster young youth, about families and sometimes maybe it feels like there's not anything that can be done, but I just do want to say, like, there are solutions to some of these problems.
Just one quick follow-up.
Very good. Representative Johnson, you recognize.
Yes, thank you so much. I appreciate that. And as someone who is a teacher of kids with disabilities, I get very nervous, and I've heard some really traumatic stories of kids being removed and being in these transitional placements, and just lots of bad things happen because of that disability. So how can you elaborate on how that can affect a disabled youth?
Yeah, I'll take this one. So when that was sort of what I was trying to get at in terms of wanting more specificity around when that finding of assault is made, having the court look at whether or not the placement is appropriate to meet the needs of the young person. And I think also looking at whether or not the alleged assault was related to staff misconduct or inadequate training, and whether it was related to the young person's disability. So oftentimes when a child's needs are not being met, There are situations where behavior that would qualify as an assault arises. And I think there's opportunity for de-escalation and behavior intervention plans that aren't always pursued in some of these residential facilities. And so having more language around ensuring that those young people who are being considered for an extension are actually in a setting that is appropriate to meet their needs is crucial to ensuring that we're not, unnecessarily extending the amount of time that a young person is staying in a residential facility, and especially one that isn't designed to meet their needs. So, and just piggybacking a little bit off of what Jasmine was saying, Chairlady Littleton's bill does talk about DDA consulting with DCS on this particular population of young people and ensuring that where they are placed is appropriate for the needs that they have. And so I do also just want to, emphasize that point that there's potential for that assault provision to really sort of undermine what's trying to be accomplished in that bill.
And to be clear, I think that was HB 2188, if I'm correct. Yeah.
Very good. Members, any additional questions for our guests? I have Representative Ashley, you're on the list.
Move, we go back into session.
Very good. Motion's been made. Any objection? Seeing none. Appreciate you all being here. Thank you.
Thank you.
Now we're back in session, members, and we're back on the bill as amended. See if we have Leader Lambert, you recognize, sir.
Mr. Chairman, I've met with these folks in my office and I understand the concerns, and there was an amendment that I think alleviated some of it, obviously not all their concerns, but we are talking about children that are in DCS custody. I mean, these are children that have already had an adjudication of some sort, and if they assault a DCS caseworker, if they assault someone that's in the facility they're in, it's just not an option to immediately put that child back into a foster home without some additional resources. And exactly what the ladies were talking about, quite frankly. And so this would extend out the time that they are in custody, which means a group home, which means a facility that's there for their care. We are talking about the juvenile system. When we talk about custody, these are children who, quite frankly, their families and their communities have failed them. These are children that have extreme needs. And DCS is trying to do the best they can in a difficult circumstance. But this just extends out by 6 months the amount of time that DCS is taking to evaluate that child to determine what type of needs are what type of needs need to be met. But to try to put that child right back out into a foster home right after they've assaulted a DCS employee is just not working very well for either these children or foster families or DCS employees. So that's what the bill does. And then the task force, I think everybody agrees is a good idea, regardless of how it's structured, to continue to look at this. And I mean, look, some of these kids are older teenagers and quite frankly, are very difficult to place. Because some of them have some pretty severe needs and are very strong and can be very violent. And so DCS is trying to help. They're trying to do the best they can, but it's just so many very difficult circumstances for the children that we're talking about that are in custody in these circumstances.
Very good. Next was I have Chairman Todd, you recognize. Okay, you pass. Members, any additional questions? All right, Representative Powell.
A question for the sponsor. Can you speak to, I know the speaker referenced Virginia and the way they did it. I mean, I do have concerns about some other things, but part of this where we're only having 4 meetings. And then also realize that this is due, they talked about expediting this, which I hear a lot of my constituents about concerns with DCS. So the report is due February 1st, 2027, which as you know, is usually comes probably after our bill filing deadline, which also, I would hope we'd have this in time to, if we need to take further action legislatively, we could. So could you just speak to those 2 concerns that I have?
Chair Lady Littleton, you're recognized.
Thank you, Mr. Chairman. Normally, the first meeting is the process of what the task force would do and what the rules would be and just go over those type things. That's normally what the first meeting does. Is that what you meant? Yeah. I know what you were talking about meeting so early.
Well, I guess what I meant was, I mean, I find, I don't know if 4 meetings is going to be sufficient to actually deliberate and have meaningful change. And then also why we set the deadline after, February 1st, 2027, which could be just a coincidence, but it seems somewhat odd to me that occurs right after what might be usually around bill filing deadline for the next General Assembly. So if you could speak to that.
Yes, I file captions for things just like that. Usually, for years, I had like 2 or 3 captions just for DCS problems. So that's how I would take care of it.
Very good. Members, any additional questions for the sponsor? Seeing none, any objection to the question? Seeing none, Madam Clerk, you'd open the board. Members, we'll be voting to send House Bill 2526 as amended to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Has everyone voted? Any member wish to change the vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 9 ayes, 7 noes, and 1 present not voting.
House Bill 2526 as amended is moved to Finance, Ways and Means. Next item 55, that is House Bill 2241, is off notice without objection. And that brings us to House Bill 59. Back to Chair Layla Littleton. That is House Bill 2082. And you got a motion in a second. You're probably recognized on the bill. I'm looking at House Amendment 013451. And that is okay, Representative Harris, I believe, had that amendment.
Motion.
Looks like it's been filed.
Motion. Can I get a second?
Second.
And I'll just ask the sponsor, is this a friendly amendment to the
It is
bill?
not.
It is not a friendly amendment? Okay. All right. Representative Harris, you are recognized to explain your hopes on House Amendment 13451.
Thank you, Chair. So I brought this amendment in subcommittee, but I didn't have a second on that. And so I was bringing it again just to make sure that when we pass this legislation, that the courts provide the parents and the legal guardians with some type of list of community resources related to mental health services and support groups. And that's all that this does.
Okay. Members, all those in favor, any questions for the sponsor? Seeing none. All those in favor of adopting House Amendment 13451 onto House Bill 2082, say aye. Aye. Opposed, say no. No. Amendment fails. Now we're back on the bill, House Bill 2082. Chair Littleton, you're recognized.
This bill protects parents from a termination of parental rights or from anyone taking their children. It simply lets the child have enough time until they are a legal adult to decide what they want for themselves for biological sex changes or social transition. This bill does not allow a parent to abuse their child. A parent will still be prosecuted under the fullest extent of the law if they are found abusing their children. And I think I'd like to say that children don't know what they want. They're confused, especially teenagers. But I had an 18-year-old that we went to college for orientation. She was going to be a teacher. The next morning, she registered for nursing. So it just takes them a while to figure out what they want to do, especially with their bodies. So with that, I'll take any questions.
Very good. Representative Ashley, I have you first on the list.
Move previous question.
Very good. Any objection? Got objection. We're on the board. Members, all those in favor of previous question, vote aye. Against, vote no. Madam Clerk, you would take on previous question, take the vote.
Mr. Chair, you have 13 ayes, 5 noes, and 0 present not voting.
Very good. Previous question prevails. Members, we're going to be voting to send House Bill, Madam Clerk, you'd open the board. We'll be voting to send House Bill 2082 to calendar and rules. All those in favor vote aye. Opposed, vote no. Has every member voted? Any member wish to change the vote? Very good. Madam Clerk, you take the vote.
Mr. Chair, you have 13 ayes, 5 noes, and 0 present not voting.
House Bill 2082 is moving to calendar and rules. And next item on the list, that's that's item 60, House Bill 1189. It'll be taken off notice without objection. Now we're going to move back to item 56, which we had rolled 5 spaces. That will be rolled. Item 56, House Bill 1802 will be rolled to next week's calendar without objection. Item 61, House Bill 947 by Representative Brooks will be taken off notice without objection. Item 62, House Bill 2064 by Chairman Todd. Sir.
Thank you, Mr. Chairman. This bill deals with actually correcting some things in our law that are unconstitutional, been deemed unconstitutional by the Chancery Court in West Tennessee, a 3-judge panel. And this changes several things within our code, including reversing the language that we currently have that says it's a crime to go armed with a firearm or a club. And now we're flipping that language where it complies with the Second Amendment of the U.S. Constitution. And we make some other corrections about parks that the courts told us that we need to make. So with that, I'll be glad to stand for questions.
Very good. And Chairman Todd, if we could, would you mind rolling this bill 2 spaces, please?
Certainly fine with me, sir. Thank you.
Without objection. Okay. If we could back up, actually, Chairman Todd, if we could roll this to the hill of today's calendar, please. Thank you. Without objection. And item 63, that is House Bill 315. That'll be taken off notice without objection. Moving to item 64, House Bill 1472, we taken off notice without objection. Item 65, House Bill 1474, be taken off notice without objection. And that brings us to item 66. That's House Bill 1939. That's by Representative Johnson. Looks like it's failed in the Senate committee. Ma'am, you're recognized.
Thank you, Mr. Chairman. I would like to take that off notice because it's failed in Senate, but I want to thank folks in the former committees and also in the Senate committees for the discussion on this and acknowledging that we have some serious problems at DCS, and hopefully we can continue to work on that next year.
Very good. Without objection, taken off notice. And that brings us to the last item on the calendar is item 67. That's House Bill 625 by Representative Hardaway. This is not the bill that we rolled. This is a separate bill. It looks like it's been general subbed in the Senate.
Thank you, Chairman. This bill has witnesses that want to be heard next week.
Okay, well, this, are you asking to roll it for a week?
Yes, sir.
Okay, members, any objection? All right, seeing none. Item 67, House Bill 625 be rolled for 1 week. And Representative Hardaway, that brings us back to item 48 that was previously rolled to the hill of today's calendar. That's House Bill 2296, which is general subbed in the Senate. Would you like to also roll that for 1 week to see if something happens in the Senate?
Yes, sir.
Okay, very good. Members, any objection? All right, seeing none. House Bill 2296 rolled for 1 week. Then without objection, I'm going to take just one moment. All right, members, that brings us back to the hill of today's calendar. That will be House Bill, item 62, House Bill 2064. Chairman Todd, you recognized.
Thank you, Mr. Chairman. I appreciate the support of the committee on this. The Senate, as we know, a little over a week ago, Senate Chairman in the Judiciary Committee sent a lot of bills to a January calendar and kind of delayed their action without any conversation or anyone even debating the bills. I'm understanding there's some negotiation going on to get at least this bill back up. And I would like to roll this a week, and let's monitor that and see if they are able to accomplish that, please. Roll 1 week.
Oh, Chairman Todd, you're requesting
Yes.
your bill to be rolled for 1 week.
Yes,
Members,
please.
any objection? All right, seeing none. House Bill 2064, item 62, House Bill 2064 will be rolled to next week's calendar. And that will bring us members to right at our 1:30 time. So without objection, excuse me. We do have. Yeah, the House Bill, excuse me. Okay, let's take care of one more thing, folks, before we leave. Item 29, House Bill 1455 will be rolled to next week's calendar as well without objection. And with that, I'd take a motion to adjourn. Very good.